Rise. The Justices of the Appellate Division, Supreme Court, First Department. Please heed the all persons having business with the Appellate Division. You are here, give your attendance, and shall be heard. Please be seated.
Okay, good afternoon and welcome to the Appellate Division First Department. I'm about to call the calendar. When you hear your case called and you answer, please indicate that the time that you need for argument. I'm going to ask you to only request what you reasonably need because, as you can see, we have very busy calendars and it's unlikely that you are going to get the time that you requested on your brief. Otherwise, we would be here till tomorrow. I do want to assure you, though, that we've had your briefs and the records on appeal for a considerable amount of time prior to today's argument. So we're familiar with your cases, and I would ask you to limit your argument to the issues that are necessary to bring to our attention today. With that, the first case is People versus McCoy. 5 and 2 for the appellant, 5 for the respondent. K.E. Liggett versus Lou Realty. 6, 3, and 4. Thank you. T. Zorin is to submit. Maternity Warehouse versus Star Indemnity. 5 and 2 for appellant, 4 for respondent. People versus Frankie Santana to submit. Lowe versus Lowe. We have multiple parties on that. So we have 3 appellants. So identify who and 2 respondents. Appellant, which one? Okay. Then we have another respondent, Ms. Ferreira. She's not arguing. All right, we'll mark that submit. All right, I'm just going to point out that certainly among the parties, there are overlapping arguments, and so we have to do this in an efficient way, and you are otherwise going to be getting a big part of the calendar. So for each of the appellants, I'm going to give you 3 and 1, and while that may not sound like a lot of time, given the overlapping arguments, I think you can make good use of it. For the respondent, since there's only one respondent, I will give you the 5 minutes that you request. So 3 and 1 for each appellant, 5 for the respondent. People versus Melendez. Submit. Alesco Preferred versus ACP.
I'll request 8 and 2, Your Honor. Your Honor, respondents filed a motion to appreciate the admission of my colleague Timothy Lang, California attorney, to appear in this appeal, which was granted by the clerk.
Well, it's granted by the court, not the clerk, but I'll accept that. Yeah. Yeah. And I'm sorry, how many are you requesting? 8 minutes. 8 minutes, and but there's a cross appeal. You want rebuttal?
I can handle the cross appeal during my 8 minutes.
Okay. All right. So I'm going to give the appellant 7 and 2, and the respondent cross appellant, I'll give you 7. State Farm Fire versus Pulse Creative.
Appellant 5 and 1. Respondent 3 minutes.
5, 1, and 3. Thank you. People versus Smith. To submit. Manglani versus City of New York.
Appellant, Your Honor, 5 and 2.
Respondent Manglani 3. Respondent City of New York 3.
All right. Appellant 5 and 2. Each of the respondents 3. DeRico versus Maidman. 60 seconds. I'll give you 1 minute. Okay. All right, and it's a submit for the respondent. People versus Adrian Lopez.
Appellant requests 6 and 2.
Respondent requests 5.
All right, 5, 2, and 5. Thank you, counsel. People versus Dukes. Say it again. I know, it's hard to hear. 4 and 1, okay. And respondents? 2. All right, so appellant, you get 4 and 1, respondent 2. Lasker versus the Department of Education.
Appellant 4 and 2.
4, 2, and 4. Thank you, counsel. Tucker versus City of New York.
Appellant requests 8 and 2.
6 and 2 for the appellant, 6 for the respondent. People versus James Park.
Your Honor, appellant requests 8 plus 4.
6 and 2 for the appellant, 6 for the respondent. Zanani versus Oriska is a submit. Fusco versus Mace Avenue Medical is a submit. State of New York versus CSEA is a submit. All right, the first case on the calendar, People versus Samuel McCoy. Step up, please.
Good afternoon, Your Honors, and may it please the Court, Rebecca Martin for Appellate Samuel McCoy. Your Honors, the trial court here erred by summarily denying Mr. McCoy's suppression motion on the basis that Mr. McCoy lacks standing because he was a mere social visitor at the apartment in question.
Before we get to that, don't you have to address the issue of the waiver? Because if the waiver is good, then can we even reach the suppression issue?
Your Honor, that's correct. If the waiver is good, then the suppression issue is waived. However, in this case, the waiver is invalid for several reasons. First and most unusually is this question of the impartiality of the trial judge. This was a waiver that was in functionality imposed by the trial court rather than the prosecution.
Could you tell us what in the plea transcript shows that the court initiated that or favored it in some way?
Yes, Your
I guess
Honor.
really the case law requires that the court have initiated the waiver.
Yes, Your Honor. So the court, first of all, this was a plea bargain that the prosecution was asking for a higher amount than what the court ended up giving. Also, the court stated that they always include a plea waiver, which implies regardless of what the prosecution wanted to do on that. And the court at one point said, I am asking for this waiver. And I think on top of the fact that the court was the one imposing the waiver, because I know this court hasn't actually gone along with the Second Department in finding all such waivers suspect, but the court also discouraged Mr. McCoy from pursuing even some appeal issues that survive a waiver. So I think when you take those two things together, the concerns that the Second Department articulated in Sutton become really clear.
Also, isn't there a direct, here, if you look at the minutes, the people specifically asked for a waiver of right to appeal right up front.
They do, but the court then went on to say, like, I will always impose that. And I think that the real concern in Sutton is not this technicality of whether the court is imposing it, but whether the court is being impartial when looking at, like, the plea bargain and whether a waiver is appropriate. And I think the court here, by saying, I will always ask for a plea waiver, and I am the one opposing this waiver.
Also, isn't it true that in reality, the court doesn't have the power to modify the plea bargain?
Your Honor, here the court is the one who ended up saying that they were going to be offering a lower sentence than the one that the prosecution was asking for.
Right, but this is not a case where the defendant pled to the docket, correct?
That's correct.
So in that regard, because the defendant did not plead to the docket, the plea bargain remained within the power of the district attorney.
Your Honor, I would agree with that. But again, I would say that the focus here is on the question of whether the court was impartial when overseeing that plea bargain and of the appeal waiver. And I would also say that beyond this question of impartiality, the waiver allocation itself was muddled and hyper-technical. The judge talked about the interest of justice jurisdiction, renewing the entire case, constitutional speedy trial, all of these technical terms that he then did not explain and that by themselves don't elucidate what is an appeal, what is a waiver. And so for those reasons, our stance is that this waiver is invalid and you are able to reach the merits of this case. To turn to those merits, it is the important point here is that Mr. McCoy did make out enough facts to establish standing for the purposes of granting a MAP hearing. The apartment in question belonged to his godmother. He was there visiting her for Mother's Day. He had a lifelong connection to the apartment, and that is enough.
Is there a strong argument to the contrary under the circumstances of this case where he didn't have a key, he didn't store any property in the apartment, he didn't stay overnight on a regular basis, he didn't contribute to the apartment expenses, all which would be indicia of expecting a privacy interest, and none of those were present in this case. What is there in the absence of all those factors that would support your argument?
Your Honor, what is there is this lifelong relationship to the apartment and this familial relationship to the host.
Except, counsel, didn't the host say, I hadn't seen him for months, and one day he showed up? So when you're saying, oh, the host, that's not really borne out by the record. The record is that she said, the godmother, I hadn't seen him for months, and he showed up out of nowhere.
Your Honor, first, we would say that there's actually a factual dispute about when he had last been to the apartment. The defense motion said that he'd been a frequent visitor since childhood. It didn't put a cabin on when that frequent visiting had stopped. And I would also say that there's no case law that says several months is enough to sever like a lifelong connection. He was there visiting her for Mother's Day, perhaps to make up for the fact that he hadn't seen her for several months. I think everyone understands that you can have a familial relationship and maybe, fall down on your childly duties for a couple of months and then make up for it.
All right, let's hear from your adversary. You'll have time on rebuttal. You may proceed.
Your Honors, and may it please the Court, Anna Notchik for the people. Defendants claim that the suppression court erred in summarily denying his motion is barred by his valid waiver of appeal and in any event is unavailing. This case and the appeal waiver in this
Counsel,
case...
what effect does the judge's statement that he always includes the waiver of right to appeal in such pleas, what effect does that have?
Well, Your Honor, the important part here is that the people requested the waiver. So the fact that the judge said he always includes that is not an issue in this case because the people explicitly rejected it. And this court has rejected to follow Sutton. In Sutton, the court demanded the appeal waiver, but here the people requested it. Also in Sutton, the Second Department found that the people were not party to the plea. Here, the people's consent is presumed in the plea because defendant did not plead to the full indictment. Therefore, the appeal waiver is valid, and that bars consideration of defendant's suppression motion claim.
What do
However,
you make of your adversary's argument that with regards to standing, that the fact that he had a lifelong relationship with the godmother, which is the tenant in that apartment, that suffices?
Your Honor, that does not suffice because it was not sufficiently pled. After Justice Obis noted that defendant failed to move to initially suppress the gun, he filed an unsworn letter with double hearsay, ultimately attributable to Andino. All the letter alleged was that Andino was his godmother, that he had frequently been a visitor since childhood, and that he was invited in on the night in question, and he was friends with her sons. That is not enough to show that he had a reasonable expectation of privacy within the apartment. He didn't allege he had keys, or that he had the right to exclude others, or that he kept any clothes there. Those are all facts that defendant would have known and could have alleged had they existed. If there are no further questions, we ask that you affirm.
Any questions, colleagues? Thank you. We'll hear from counsel on rebuttal.
Your Honors, I would like to make a couple of points. First, just briefly on the waiver, I'd like to just once again emphasize that on top of the court requesting the waiver, they did also add this additional element of discouraging certain appeal waivers, which is a highly unusual fact. As to whether or not there was enough in the waiver or in the motion, we believe there was. I would like to emphasize on the issue of the motion being unsworn. That is not something that the trial court addressed or seemed to take issue with. They took the facts in the motion as a given, so that issue is foreclosed by LaFontaine. And I also want to emphasize, really importantly, that's what is unusual here is the fact that it was a summary denial before a MAP hearing. In Jose 1 and 2, this court made it clear that what you need to plead to get to a MAP hearing on the issue of standing is not the same depth of what you need to plead at that MAP hearing. And the vast majority of cases that were cited by the trial court and by my opposition are cases where whatever was in the papers was enough to get you to a MAP hearing, and then at the MAP hearing, further facts were developed, and then it was found there wasn't standing. What's unusual here is you have this indication of this lifelong connection. You have all of these facts that do suggest there is at least an issue of fact about whether or not there is standing, and there still wasn't the opportunity to address that in a hearing. And for those reasons, we are asking that you reverse for the purposes of a MAP, for granting a MAP hearing. If there are no further questions.
Any questions?
Thank you.
Thank you. Thank you both. The next case is Liggett versus Lou Realty.
Good afternoon. If it please the court, Paul Gruber from Borough Goldstein, Altshuler, Naines, and Goydell, representing Lou Realty. The order appealed from denying defendant's motion to dismiss the complaint should be reversed because it's premised on a misstatement of the facts which are clearly established by the record. Mr. McKinney was never the rent-controlled tenant of this apartment.
Counsel, if he was never the rent-controlled tenant of the apartment, then why did he have standing to agree to what the fair rent would be in the future under that agreement, and why was that? Why is that appropriate?
Okay, Mr. Brown, who was the rent-controlled tenant listed on the initial registration in the record, as well as other documents in the record, died. I think it was in 1998. Those details are more fleshed out in the subsequent litigation, which is not before the court, but the court can judicially notice if it feels it's necessary. Mr. McKinney was occupying the apartment.
I know that, but why did he have standing to agree to what the fair rent would be for that apartment if he didn't have standing at all?
Because he agreed because Mr. McKinney, in settlement of a holdover proceeding in which he sought to be the rent control tenant and where the landlord sought to evict him, agreed that he would become the first rent stabilized tenant. When a rent control tenant vacates, the next tenant, unless deregulated for some reason, would be rent stabilized.
But what I'm troubled by is that essentially you're permitting him to stand in the shoes of future rent-stabilized tenants. And I don't understand why he had standing to do that under this agreement.
He was being sued for eviction. The apartment had no tenant technically, and the landlord was free to rent it. This is not really
So
much
your
different.
position is that because he was the first rent-stabilized tenant following a rent-controlled tenant,
Correct.
he had standing in terms of the first rent and any fair market rent appeal. That's the way the law is structured, isn't it?
That is correct. That is correct, and that is what we say.
So let me ask you, because the arguments in this case seem to have changed from what they were focusing on below to what is before this court. Below, the issue seemed to be whether or not he gave up a right to be a rent control tenant, which does not seem to be the argument we're having now. The argument seems to be whether or not it was valid in that stipulation to set a preferential rent of $650 and make the legal rent $1,650. So why isn't that an invalid attempt to get around the rent stabilization rules by agreeing to a legal rent that was so close to what would make it ultimately deregulated?
Well, that isn't. First of all, as we note in the brief, and I could explore this more if you want, we don't believe Mr. McKinney had any rights to waive in that respect prior to settling the case and signing the lease.
The right I'm asking about,
I know.
let me focus. The right I'm asking about is not waiving a right of rent control, it's waiving rent stabilization rights for future tenants.
Right. And the rent stabilization law says that the first rent stabilized tenant, the initial regulated rent, is that which the parties agreed to in a lease. Now, at the time, there was a concept known as a preferential rent. It still exists. This court in Missionary Sisters versus DHCR, about a year after this stipulation of settlement was made, stated that the entry into a preferential rent agreement does not waive a right under the rent stabilization law.
So, counsel, let me just ask you, am I correct that the landlord could have finished that holdover, McKinney could have lost, and the landlord could have set with the next tenant the rent at $1,650, correct?
Or, on the other hand, McKinney could have won and the landlord would have another rent-controlled tenant. But,
so they decided neither side wanted to take that risk.
yes.
So that's where they ended up.
Exactly. The, I can fill you in on a little detail of the litigation. There were cross motions for summary judgment. There were issues of fact found. Mr. McKinney, in the succession case, would have had the burden of proof. We can speculate that he and his attorney weren't entirely comfortable with that. And we can definitely make the same speculation with the landlord, that they weren't entitled.
The landlord agreed that he could be...
That's why we settle cases, and that's why we
The landlord
respect...
agreed as part of the settlement that, hey, you can be the first rent-stabilized tenant. I'm not going to give you rent control, but I will make you the first legal rent-stabilized tenant of these premises.
Yes, those were stipulations that were done routinely in housing court. They were enforced. This court recognized a similar kind of stipulation in the Bedford Apartments versus Kent case.
But counsel, isn't it different because in this case, Mr. McKinney had no skin in the game, essentially, as to the $1,650 a month rent?
It was
Excuse me, since he was only being required to pay $650 a month. So why would we... It seems to me that that's a different kind of agreement than if he was affected by it, and he wasn't affected by that at all. So why should we honor that?
Well, first of all, we don't know exactly what Mr. McKinney paid on this record. Secondly,
I'm sorry?
We don't know exactly what he paid on this record. We know what he agreed to pay.
Right.
But more importantly, if I can go over a second.
You can answer that question, and then we'll hear from your adversary.
The Rent Stabilization Code, Section 25.21, A1, I believe, addresses the situation of what the initial legal rent is in this type of situation. There it says it's the rent agreed to by the parties. I'm paraphrasing a little bit. But later on in that section, the DHCR in its code addressed certain other types of situations where rent stabilization comes into play. The 421A situation, the 421G situation. Section 2521.1G, they use the language there, the initial rent is that charged and paid. In 2521.1H, they use the language that the initial legal regulated rent is that lawfully charged and paid. We don't have that language in the part that governs your garden variety, private landlord, private tenant, no subsidy, no regulation, no tax benefit kind of situation, which is what we have here. And we can't import the concept of paid into this statute. That's our position. I'll save the rest for rebuttal.
Okay, thank you.
Roger Sacker, Newman Ferrara, for respondent. Justice Scarpula, I want to take your question head on. We talked about neither side wanting to take the risk as part of this settlement agreement, but the thing is, you can't pass that risk on to future tenants. It's the same thing we did with that we underlined in Churnett, that you can't make an agreement that affects future rent-stabilized tenancies. That goes back to Drucker v. Morrow.
So then how do you distinguish all the cases where we upheld that?
Because there was an uncertainty. Here, what they did
Here, there was an uncertainty.
Right,
He was
and
claimed to be a squatter. So, I mean, this is not the first case like this. That's what I'm saying. I don't know how you get around all the law that we have in this department.
Because
a couple of cases that said that in this circumstance, you are entitled to that we will enforce those stipulations, then we're not going to go back 20 years and try and figure something out. Because the fact of the matter is, Mr. McKinney could have lost. And then that apartment, the next tenant, the landlord could have said, I'm going to set the rent, you and I are going to agree that the rent stabilized rent is $1,800, correct?
he could have done that,
So
yes.
that is what I am saying, and we have upheld those stipulations in our cases. So I don't see why all of a sudden now we would not do that.
Because there's a problem here. There's two rents. One is $650. One is $16.
So what's illegal? That was going to be my question. What is illegal? Assuming he had a right to settle his lawsuit where he was claiming rent control and the other side was saying you're a squatter, and they settled up by saying, okay, you can be the first rent-stabilized tenant, which is a fair settlement. So what is illegal under the law about setting a different preferential rent than a legal rent? The law at that time specifically allowed landlords and tenants to enter into that agreement. So why should we set it aside what was completely legal to do?
Because you have two rents. You have the stipulation of settlement says itself. It says rent agreed on. It says we're going to charge you rent.
Where does the law say that's not allowed? That's my question for you. Where does it's the only law I found said it is allowed to set a different preferential rent than a legal rent. There's nothing improper per se about that. So why is it improper?
Not on the first tenancy after a decontrol. On the first tenancy.
Well, that's not exactly true, because what happens is, and that's why I know you argue this isn't a fair market rent appeal, but it kind of like is, because in fact, the remedy would be that the tenant had 4 years to contest that rent. I might also add that under the rent regulations, clearly a preferential rent was permitted because it required the landlord to otherwise register both the preferential rent and the rent that in the lease they're claiming is the rent stabilized rent, and that needed to be registered with the DHCR for the world to see. So there was nothing per se prohibited about giving a preferential rent.
Except that the preferential rent is the fair market value for the apartment. That's what someone is willing to pay. These two guys got together and said, well, we won't challenge the fair market value.
You don't know. You don't really know what the negotiations were or why they came to that conclusion, do you?
I wasn't even, I think I was still in high school.
Okay, there you go.
Precisely, right?
Counsel, isn't the problem that the concept behind the rule that it should be the amount agreed on between the landlord and the tenant is that both the landlord and the tenant have an investment in what that number is. And this tenant didn't have any investment in what the 1650 number because it didn't apply to him.
Exactly.
Well, maybe he
Exactly.
did because he had risk that he would be thrown out altogether. I mean, you don't know what went into the negotiation.
Right, it could,
But you
You
can't
just
mitigate your risk by agreeing to whatever rent the landlord wants to put
Why
in,
is this
because
case
you've
different?
eliminated your risk and transferred that.
Why
But
isn't
you-
this case different than any other case where the landlord and tenant agree to have a preferential rent and a legal rent? What makes this case different than any other case where that occurs?
Because you're setting a future rent. At the time that this happened,
How do you know
remember,
that's
there was
not a
no
market
HSTPA.
rent?
Where's the law that says that's not allowed in a first rent stabilized rent as opposed to, where does the law say
Because
that?
then what you would have otherwise, because when it says you register the rent, the tenant, it memorialized in the lease, right? So let's ask our first question. What is the rent memorialized in the lease? Is it $650 because the lease says $650? Is it $1650 because the lease says $1650? If you allow for a registration of a preferential rent on the first rent after decontrol, let me tell you what's going to happen. The landlords are going to say, we're charging you $4,000, $5,000, $10,000. We're going to give you a preferential rent of $1,000. Okay, say that's the fair market value of the apartment. The whole point, the whole tie-in, is that first rent is supposed to be a fair market
Can I
rent.
ask you a question? What do you have to prove that it wasn't a fair market, the non-preferential rent? I mean, why do you assume that $650 wasn't a preferential rent compared to the market as it existed at the time when he became a rent-stabilized tenant?
Because the way what a preferential rent is, what it's defined in the code, is the amount that the tenant was charged and paid. Justice Scarpullo, you remember we had that whole debate in Chernette. The amount
But
charged
you
and paid.
don't, in other words, you don't have any comparables that indicate what was going on in the marketplace at that time.
Oh, not,
Not at all,
not
no
on a
proof.
motion to dismiss this early in the
Okay.
litigation.
Okay,
Thank you.
thank you. Let's hear from rebuttal.
And so, counsel, I'm going to go straight at it. Is there anything in the law that would prevent that first tenant and landlord in this litigation to kick the tenant out from setting a preferential rent and a regulated rent and a preferential rent? Is there
Nothing that I
anything would
found, Your
prevent
Honor.
it? No statute, no law, no nothing.
No,
It
nothing.
could be that the landlord liked that guy and knew he was an older guy, didn't want him to move out. There could be a million reasons, correct, for that? Other than I want to scam the system.
No, this wasn't a scam of the system. This was, frankly, 22 years ago, we couldn't anticipate what the system would be like today. And that's a tremendous problem.
Counsel, would you agree that Mr. McKinney had no reason to negotiate whether the 1650 was 1650 or 1750 or something higher or lower, because it didn't affect him at all, right?
I can't answer that question because
Well,
I
there's
don't know what Mr.
we don't
McKinney
know
was
of,
thinking.
excuse me, we don't, on this record, we don't know of any way.
no,
excuse
no.
me. We
But he
don't
was
know, excuse me, am I correct that on this record, we don't know that he was affected in any way by what that higher amount was, right?
On this record. But on the other hand.
So let me ask you, would it be possible, for example, his nephew to move in the next year and claim succession rights under rent stabilization?
From Mr. McKinney?
So there would be some
Absolutely, yes.
circumstances where he would care whether the legal regulated rent
Absolutely,
is
yeah.
650 or 16.
Absolutely, yeah.
Right?
So there's a reason for it.
We're all talking about who knows.
Right.
But there's nothing in the statute that says you cannot do that.
No, nothing in the statute. And as I pointed out before, when the rent, DHCR wanted the rent paid to matter in this first initial rental, they said so, and they did not say so here. Now, everything you've heard from Mr. Sakar, I think you can draw one conclusion, that if you buy into his argument and let the courts ignore this part of the rent history and everything that transpired after that, You're opening up a tremendous can of worms that goes well past this case. And one last remark, if I may.
One last.
This court, in the Flynn matter, where Mr. Sakara represented the party, said that when you're looking at agreements concerning rent concessions, you have to look at the circumstances at the time those agreements were made. I think this is entitled to the same consideration. The order appealed from should be reversed and the complaint dismissed. Thank you.
Thank you. Thanks you to both counsel. All right, the next case up is Maternity Warehouse. You may proceed, Counselor.
Good afternoon. May it please the court. Anne Marie Bostard of Lerner, Arnold, and Winston on behalf of Plaintiff Appellant, Maternity Warehouse, Inc. This is an appeal from a summary judgment that was granted in favor of the defendant, and the court should reverse the decision because the motion court applied an incorrect standard on the summary judgment motion and failed to consider relevant evidence that established the existence of a disputed material fact.
Well, assuming for a moment that there was a prima facie case made by the movant, what you offered in opposition was an affidavit of a plumber that did work on the building 4 months after the occurrence of a leak which had been previously worked on by a prior plumber, correct?
Yes, Your Honor.
And one of the reasons for the lower court saying, well, this isn't really probative, is because it didn't reflect or it didn't raise an issue of fact about what the condition was that had created the leak that was repaired simultaneously. Why does this? Why could your plumber have any relevant evidence or probative evidence that would create an issue of fact about the condition of the leak in the pipe and its cause 4 months earlier?
Respectfully, Your Honor, the question makes the assumption that the pipe was actually repaired at the time that the leak occurred in June. There was a major leak in June of 2018 that affected my client's business personal property. And at that time, there was some ongoing plumbing work in the building. There was an ongoing leak, which my client has stated in sworn interrogatory responses, that the leak continued to be an issue through October. And it was only in October that they finally identified the cause of the leak, which was when they knew that it was a broken pipe. And because they only identified it in October, that does not mean that the pipe was not in fact leaking in June, especially given that the client's testimony
Your client complained that there was a leak between June and October?
Yes, Your Honor.
Where's that in the record?
Right.
If you look at the interrogatory responses, I believe it's record 199 and 200, there is a statement from my client that they were speaking throughout that time period with different plumbers, that they were contacting their landlord, that they were reaching out and trying to repair this issue. And you'll see as well at record 203, the way that my client resolved this issue and why there was no ongoing damage during the time period was they had moved their stock up onto pallets and put a plastic cover over the top of it so that it wasn't incurring continuing damage and they weren't incurring continuing losses. That doesn't mean the leak wasn't ongoing. The leak was still a problem throughout that time period.
So I'm looking at the affidavit that you submitted, and your Mr. Brandsdorfer doesn't say anything about relating it back to the June leak. Nothing, not a single. I mean, this affidavit is literally 4 months later, I came in, there was a problem, I fixed it. There's nothing there, absolutely nothing, that would connect it back to June. So assume that this doesn't do it. What evidence did you put in to connect this pipe back to June?
Your Honor, respectfully, the standard on a motion for judgment does not require my client to disprove.
No, but you got to put in, if they put in an expert report and a bunch of stuff and they make out their prima facie, let's assume they make out
But they didn't put in an expert report. They put in an unsworn statement from a purported expert who has never been cross-examined.
Let's assume, for the purpose of my question, let's assume that the movement made out their prima facie. How did you rebut it and raise an issue of fact by an affidavit from someone who doesn't relate this, what this person did, back to June?
I'm sorry, could you repeat the last portion of your question?
How did you raise an issue of fact? Let's assume that the movement made out their prima facie. This affidavit doesn't raise an issue of fact because
It does, though,
doesn't
Your Honor,
relate-
because it establishes that the pipe was in fact broken. And while there is
4
not,
months later, but there is nothing to connect, and there is nothing that your
but on a
affidavit
motion for
states.
summary
Let me just
judgment,
finish
the
this.
obligation of the court is to draw
Counsel?
all assumptions in favor of the non-movement.
You have to let the judge speak. You can't speak over the judge.
I'm giving you all, you have to.
My apologies.
Something has to connect it back to June. We're talking about an event from June. There is not a single word in here connecting it back to June.
Right.
So yes, this affidavit says 4 months later, this happened. But there's nothing in here. So aside from this, is there anything else to connect the broken pipe back to June? Because it's not in here.
Yes, Your Honor, in the record, there is a statement from my client that the leak was an ongoing problem through the end of through October. And the fact that the problem was ongoing means that the repairs that were conducted in June did not solve the problem. Therefore, it was not the source of the problem.
Or it could have been another problem, right?
Right. I see my time has expired.
Yeah, let's hear from your adversary. Thank you. Right, you may proceed.
May it please the court, Andrew Mandelbaum from Kelly and Curtis for Defendant Starr. Your Honors, you hit the nail on the head with regard to the question.
Well, not really, because I think that we have other nails that we have to look at. So let's look at your prima facie case. The other side repeatedly raised the problem that you have these expert reports, but they're uncertified. And you never tell us why we can look at them, or that it matters or doesn't matter. Could you address that, please?
Certainly. Well, first, I believe we're talking about two different reports. The first report, and really the crux of the argument and the crux of the case, is that the plumber that was actually retained by maternity or the landlord is the plumber who determined that the leak in June.
He had personal knowledge. That's not a report. That's just his affidavit and his invoice. Maybe that's enough. I don't know. But they do talk, but then you put in and you repeatedly rely on, when you were doing your client was doing the adjustment of the claim, the experts that they went in to take a look at it who came to conclusions. But those reports are not certified. That's true, right?
There is one report that is not certified, which only was prepared and submitted long after the incidents involved in this case.
So you can't rely on that for your prima facie case. That we agree, right?
Not as an expert report for this purpose, but we certainly can rely on the facts that he raised and the facts that were presented, as well as the facts from we presented evidence from the plumber who actually conducted the work.
Well, that's something different, right?
Right.
And is that enough in and of itself?
Certainly it is.
For a prima
The plumber that was
facie case?
retained by maternity and their landlord determined the cause of the incident. Starr reviewed that, had an adjuster. There was also a public adjuster. They evaluated the claim. They paid the applicable sublimit. We never heard again from maternity or from their landlord at all until December.
But do you know, you don't know whether the tenant was continuing to complain to the landlord about a leak.
Well, we don't. We asked for that information in discovery. There was no response. There was
You
no
didn't say it
evidence.
in interrogatories, your adversary is incorrect?
No, so the page 199 that my adversary points to discusses three plumbers. The initial plumber, American Minuteman, which we discussed, who submitted an affidavit that said they were never contacted again by maternity, by Brosel Realty, by anyone with regard to this claim, and their invoice was paid in full on the day.
And that was the plumber who did the repair at the time it was reported,
Correct.
right?
And we discussed already the plaintiff's second plumber, King Plumbing, Yoel Brandsdorf, who obviously was not involved in this case until October 18 of the earliest, although his affidavit actually says he wasn't involved until October of 19. And then there was one other plumber that was referenced, and it was a verbal communication that the maternity couldn't identify when it was occurred, who was on the phone, when it occurred, and it's undisputed that that plumber or any other plumber never visited the site, performed an inspection, performed any service or maintenance at any time between the June leak and the October, I guess, repairs. There's absolutely no evidence in the record that can relate the October repairs back to the June leak. And in fact, even if we give maternity the benefit of the doubt that the pipe was broken in October, it still doesn't satisfy the situation here where there was a leak in June, it was addressed in June, it was repaired in June. No one ever reached out again anytime after June until this October repair. For 4 months, and for damages that could cause, a leak could cause damages of over $200,000, and consistently occurring for 4 months, and they didn't have a single plumber come in to take a look at it, to make repairs, or go back and talk to the plumber that initially performed the repairs and say, hey, listen, you guys didn't do this right, or you guys caused this problem. It's just unbelievable. That's what the lower court found, that this situation was just completely unbelievable. Based on the evidence that we presented, the court correctly granted us summary judgment, and that's why we asked the court to affirm.
Any further questions? Thank you. Let's hear rebuttal.
Counsel, I have a question. Sure. In your argument, you said that plaintiff had repeatedly complained about continuing leaks and that that's evidenced by your answers to interrogatories.
Yes.
But the citation in the interrogatories that I believe is what you cited to, it says that plaintiff states that Mr. Rosenberg communicated with Bozell Realty Corp. Regarding the incident, regarding the damage, and the plumbing problems. It doesn't say specifically that he complained there were specifically continuing leaks. Is that the only thing that you're relying on?
It is, Your Honor. And I will say, nevertheless, the court has said, the Court of Appeals has said in Weingrad versus the New York University Medical Center, that on a motion for summary judgment, the court must deny the motion regardless of the opposition insofar as the defendant fails to, the movement fails to prove its case.
Yeah, we understand. We totally get that principle of law. So now let me ask you. Your adversary says, and I grilled him quite extensively on it, that his prima facie case is satisfied by the affidavit of the plumber who did the work in June. Why isn't that sufficient?
A couple of reasons, Your Honor. The most important of which is that the person who signed that affidavit was not the plumber who did the work. It's a supervisor employed by the same company who has no personal knowledge. And the law is clear that when a person does not have personal knowledge, their affidavit is worthless for a motion for summary judgment. So to take that into account and to rely on that as the basis for your prima facie case is completely insufficient and incorrect. Moreover, as counsel has stated, this is a credibility question, and the law is equally clear that credibility is not something that can be resolved on a motion for summary judgment. It's a question of fact for the jury. If there are no further questions, thank you.
Thank you. Thank you both. The next case for argument is Lowe versus Lowe. Okay, okay. All right, you may proceed, Counselor.
Good afternoon, Your Honors. Robert Abrams for the appellant guardian, Judy Mock. Guess, Your Honors, I want to just begin by stating that this is an Article 81 case. And in this case, Judy Mock was appointed to be the guardian for Edgar Lowe only after Edgar Lowe, the incapacitated person, nominated her, the family nominated her. That's an important point because she was appointed because Edgar wanted her, and Article 81 is very clear that the preference of an incapacitated person plays an important role. But even more importantly, the reason why—
At that time, there were also serious questions about his decision-making ability, correct?
Your Honor, Article 81 is very clear that somebody could be deemed to be incapacitated, but that doesn't mean that they're totally incapacitated and can't make their own decisions. In fact, in this case, Edgar had both issues of capacity and issues having to do with his psychiatric behaviors, where he had potential issues of mental illness. But clearly, he had the capacity to make certain decisions, and in fact did make decisions on his own. And to go one step further, Article 81 is very, very clear that if an order doesn't preclude an incapacitated person from making decisions or take away certain abilities for them to make those decisions, they have the right to make those decisions. Edgar is an alive human being with feelings and emotions. He clearly
I think we understand that, honestly. We're very sensitive to the needs of IPs, so you don't have to remind us of that. We're also sensitive to the obligations of guardians, and they continue. They're ongoing after the appointment, correct?
That
I
is-
agree with that.
Absolutely, Your Honor.
Right. And so Ms. Mock was appointed the guardian, and there were questions almost at the outset regarding the nature of his capacity and his cognitive ability, so much so that at the original Article 81, the court would not allow him to simply consent to a guardian. She held a hearing, correct?
That's correct, Your Honor.
Right. And then one of the things that was raised almost at the outset by the court evaluator was the fact that after the Article 81 was brought, that Mr. Lowe got married, correct?
There were...
After. It was after. The Article 81 was brought.
After the, I'm sorry, after the commencement, that's correct.
Right, and he got married within days, correct?
That is correct, Your Honor.
And the court evaluator was concerned, given the evaluation by the court evaluator of the cognitive ability of Mr. Lowe, and the fact that the marriage came with a prenuptial agreement, and whether he had the capacity to otherwise agree to the agreement and otherwise get married, correct?
That is...
It was raised. And then Judge, I'm just trying to recount the history, and I know it's very complicated. So Judge Kennedy was in charge, and she said, you know what? I'm going to first decide the issue of whether there's a guardian, right? And
Yes.
She said a guardian was needed and put Ms. Mock in, right?
That is correct.
Okay, and then we get...
Well, Your Honor, actually, there's one very important point, Your Honor. She said, let Ms. Mock in after she was nominated by Edgar Lowe, which goes to the fact that,
Well,
in fact, had some
she was a
decision-making.
temporary guardian, and she just happened to be, when she was put in as a temporary guardian, Mr. Lowe didn't know her, right?
That's correct, but he was the one who
Okay.
nominated her and agreed to her appointment.
Okay, I accept that in the chronology. All right. What happened, though, is that Judge Kennedy, at least in her colloquy, said, all I'm deciding is whether he needs a guardian. He does. And once I get that wonderful guardian in place, the guardian has to look to see whether this other serious issue about his marriage and the agreement are something that should be enforced or maybe otherwise other action taken, correct?
That is correct, Your Honor.
But what happened is that Ms. Mock didn't investigate. She admitted before Judge Sharp that, in fact, she didn't think it was her obligation to investigate. And so nobody has looked into whether at the time that Mr. Lowe agreed to get married, agreed to give $10 million if he divorced his wife for any reason or she divorced him, and I think an even larger sum should they die married. Nobody looked at whether that agreement signed shortly before the court declared him incompetent sufficient to have a guardian, whether that agreement should otherwise remain in place. Isn't that a serious dereliction of duties by the guardian?
First of all, Your Honor, that is not why we're here today, and it's not why she was removed by Justice Lowe.
Well, it was part of the
decision was
motion to remove her.
But that is not the reason why Justice Lowe did remove her.
Okay, all right, so let me get to a different question.
But if I may...
Can we remove her, or can we affirm this on a different ground so long as it was in the motion to remove her as a guardian? and she had an opportunity to address it.
Well, Your Honor, it's in the record that Judy, as the guardian, had discussions and was given, in her opinion, the right to make a determination as to whether or not to challenge that marriage or not. And she was very clear about the fact that Edgar and Rashida were very close. She felt that given the amount of money that Edgar had and observing the relationship between Edgar and Rashida, that she was not going to challenge that marriage at the particular time period that we're talking about.
Well, she didn't even think she had the obligation to do so. I have colloquy in the record, a transcript, where she said it was not her duty to do so.
Again, in terms of the record itself, the record also was clear that prior to the marriage, Edgar had a divorce attorney, and he was under the care of a psychiatrist, and also there's a court examiner appointed by the court, and all those individuals were supportive of the position that Judy took in terms of the relationship between Edgar and Rashida.
Well, how would the court examiner know one way or the other? And I don't, it was her duty. They don't know whether she carried it out or not. That's exactly one of the reasons that that Ms. Ferreira was appointed to kind of look into the circumstances of why this wasn't investigated and whether the guardian shouldn't have been more diligent in otherwise fulfilling her fiduciary duties.
Assuming for the purpose of discussion, Your Honor, and I appreciate the question, if that was the case, then there should have been a hearing and there should have been an opportunity for Judy to explain why she took the position that she did. Please understand, Your Honor, in addition to Judy, there was a court-appointed counsel who was assigned to protect Edgar's interests.
No, I know that. That was kind of an interesting thing because they're kind of walking hand in hand on this, and I'm not sure they're really in the same boat. But let's say, I'll tell you what, let's hear from Mr. Elias's counsel on what their position is with respect to whether he should have been removed or not.
Thank you, Your Honor.
Okay, and understand, I know how complicated this is, and I don't want you to think that this is only going to be decided on the basis of oral argument. We have extensive briefing on this, and we are familiar with it, okay?
Right.
All right.
Thank you, Your Honor.
Yeah.
If it please the court, Mark Anish from Lewis Brisbois representing Respondent Gary Elias. In my 3 minutes, I'd just like to begin by focusing on the 2/24/2022 order dismissing Gary Elias as the court-appointed attorney.
Counsel, I have a question.
Yes.
Is there any evidence in the record that Mr. Elias ever took any steps to conduct any investigation of the validity of the prenuptial agreement and marriage, as was recommended by the court evaluator?
There isn't much in the record because there was no hearing where he could defend himself.
Well, but he put in papers, that's one of the places he could have put it. Is there anything in the record that shows that he ever took any steps to conduct that kind of investigation?
Other than talking to the IP, other than talking to the IP's physician, and his affirmation that he submitted, no, because our position was he was dismissed before he had an opportunity to show what he did.
Why wouldn't he put it in the papers in opposition to the motion to be removed, which raised the failure to investigate whether it was a bona fide marriage and prenuptial agreement as one of the primary reasons to remove them?
I wasn't counsel at the time, but from what I understand, he put in papers specifically requesting a hearing which he could defend himself and present evidence to that effect.
Well,
He was never given that opportunity.
But let's go back. Certainly before you remove a guardian, or from my point of view, before you remove a guardian, there's got to be some, or an attorney, some due process, right? That doesn't necessarily involve a testimonial hearing unless there are disputed issues of fact that need to be determined by the court. As in, say, the most recent, the Roberts case, the Maxwell Roberts case that everybody is citing, right? So wasn't there an obligation on Mr. Elias, to otherwise put forth some facts for the court to say, okay, we're going to have a hearing on this.
Your Honor, in Roberts, the court said that they can't rely on a simple affirmation from a court evaluator. Whether or not he objects to it or not, he has to have an opportunity at a hearing to cross-examine the court evaluator, or in this case, the special guardian, to determine what investigation, if any, she made. She's making claims in an affidavit. She doesn't say who she spoke with, that the court-appointed attorney did X, Y, or Z, or didn't do X, Y, and Z. She's just submitting her own affirmation.
But doesn't he have the, counsel?
Sorry?
I'm over here.
I'm
I should
looking
have
all
taken
over.
my mask off. Doesn't he have that opportunity and by saying, put it in an affidavit, explain? I mean, you're saying he never had an opportunity. Of course he had an opportunity. He had an opportunity to put in a sworn statement of what he did. He didn't do that, did he?
With all due respect, he
No,
wasn't.
you don't have to say that, because usually that means you're not respecting what I have to say, but okay.
It's a bad habit, I'm sorry.
I'm just asking you, you're saying he had no opportunity. I'm challenging you on that, because he did have an opportunity. He had an opportunity to put it in his own words in an affidavit put in before the court, but he didn't do that. Am I wrong with that?
He did do an affirmation, but it wasn't detailed as you just repeated.
But if it's not detailed and he didn't raise any issues of fact, then there would be no reason for the court to have a hearing. Courts don't have hearings when there's no real dispute of fact.
Well,
and as far as I can tell, there was no serious issues of fact raised by his affirmation.
Under Roberts and under Gordon, they just say the court cannot conclude issues of fact based on a simple affirmation. You need to have a
But if he
hearing.
doesn't raise any issues of fact, then there's nothing to have a hearing about.
He submitted an affirmation saying he did nothing wrong, that he doesn't deserve to be fired.
But that's not the
And
question.
he requested a hearing.
But the question was whether or not he did any investigation into the issues that had been raised by the court evaluator, namely...
Sorry, I can't. I'm having trouble.
What?
The first court
The first court, he did not say that he had done any investigation of the issues raised by the first court evaluator as to the validity of the marriage and the validity of the prenup. So he didn't raise any factual issues as to his having done any investigation on those issues.
He wasn't dismissed based upon the court evaluator's report. He was dismissed based on the affirmation submitted by the special guardian, who didn't say what investigation either that she conducted. She just asked that he be removed. That because he followed, the special guardian dismissed him in part.
The special guardian did not dismiss him. The court dismissed him.
The court dismissed him based on the special guardian's argument that he did not respond to the court on its request about his getting out of Lenox Hill Hospital.
About the
When the record, excuse me, when the record specifically says...
excuse me. Come on. On the discharge, I was trying to help you out. You were searching for a word.
Yes, discharge was the right word.
I understand. Again, a very heated case, but we're just trying to get to the core of certain things in a very complicated record. All right?
I
so the
think
discharge the discharge of the attorney and the guardian had at least in the court order was a result of what all the parties said was sort of an exigency that was going on because he was in Lenox Hill Hospital and there was a problem or a controversy, let me just say, about his discharge plan, a safe discharge, right?
Correct. And in addition, the court said that she was expecting a report from either the special guardian or the guardian as to his status and whether he should get discharged.
Understood. So
The lawyer had
here's
no
my
responsibility for that.
Here's my question to you, though. You know, since there was at that time an extant motion to remove him on the grounds of his complicity, basically, in allowing the guardian not to investigate this very serious matter, and he had put in papers, could that, what are in those papers, be an alternate basis for this court to look at in deciding whether, one, there should be a hearing, or two, whether in fact there was an appropriate discharge here?
I think he should have been given the opportunity to cross-examine the special guardian based upon her alleged investigation that he didn't allow the guardian to discharge.
Okay, thank you.
Thank you.
All right. Okay, you can proceed.
Thank you, Your Honor. If it pleases the court, my name is Donald David. I'm from the firm of Ackerman. I represent Rashida, who is the wife of Edgar Lowe. Let me jump to the question which you have raised, right, which is the question of whether evidence has been presented to the court that deals with the validity of the marriage, which deals with the history here. My client has been involved with Edgar Lowe since 2008. She received an engagement ring from him, and in fact, they then decided to get married in 2010, and they had a break on that, and they decided again to get married in 2017, and in fact, finally in 2018, they did get married. That is in an affidavit submitted by my court, in multiple affidavits submitted by my client, by my client to the court below. So the fact of the matter is that the evidence exists and that my client supplied to the court to demonstrate the validity of her marriage.
I'm sorry, are you saying that the fact that they decided to get married in 2010 and didn't actually get married until 8 years later?
I'm saying exactly.
Excuse me.
I apologize, Your Honor.
Are you saying that that 8-year gap means that their marriage was that everything was fine and they were moving all the time towards getting married? It seems to me that the 8-year gap actually raises questions.
Well, Your Honor, if I may, I'm not saying that it means the former, nor am I saying it means the latter. What I'm saying to you is that there is a history here and a consideration. This marriage was not something that happened in a matter of days. It is something that developed over a period of years.
But you would allow me, Counselor, that if in fact it happened at a time and the agreements were signed at a time where Mr. Lowe lacked capacity to do so, that would be troublesome for your client.
Your Honor, I would agree with you if that were in fact the fact and it was demonstrated in a court with a hearing. The problem is it wasn't demonstrated. There was no hearing despite multiple...
That's right. There was no hearing regarding the issue of whether Mr. Lowe had capacity, and wasn't it the obligation of the guardian to marshal those kinds of facts and bring them to the court so that a decision could be made, one way or the other, either pro or con?
Your Honor,
Isn't that
I apologize.
Isn't that the fundamental problem here? Not whether your client might ultimately win or not, but that there was a very serious issue about his capacity at the time he gave her a prenuptial agreement and went down to City Hall and got married.
Your Honor, may I address that even though my time...
Please, it's crucial.
Your Honor, I do not believe that the guardian was given discretion by Judge Kennedy. If you look at the order and you look at the transcript before Judge Kennedy, it was discretion to investigate. There is an indication that Ms. Mock spent multiple times with Mr. Lowe and in fact discussed it multiple times. That material is in the record. It's from my client,
She's not an expert in capacity. I mean, there's also evidence that he had a diagnosis of dementia that wasn't even disclosed to the court. And the nature and extent of that dementia would bear upon whether he could sign these agreements and go down to City Hall at a time when there was already an Article 81 proceeding pending. I mean, it's got to raise eyebrows at least.
Your Honor, if I may, it may raise eyebrows, but the eyebrows go back down when you find out from Dr. Bruno, who Judy Mock did speak to and who Gary Elias did speak to, when you find out from Dr. Bruno that in fact Edgar was not diagnosed with dementia, he was diagnosed with a different condition, and in fact Dr. Bruno said he had full capacity to enter into the marriage, and that evidence was submitted in affidavits from Dr. Bruno. The problem is Dr. Bruno never got the chance to be on the stand because the court below would not have a hearing. And we were entitled to a hearing. Due process requires a hearing. Duke requires a hearing. And your decision in Roberts requires a hearing.
Okay, thank you. All right. All right.
Good afternoon, Your Honors. Frank Santoro for Respondent Allison Lowe, who is Edgar Lowe's sister. Your Honor.
Let's get to the reason, at least proffered by the lower court, as to the removal of the Ms. Mock and Mr. Alliance. And that really had to do with, there were problems concerning discharge from Lenox Hill Hospital, right?
Sure.
And there was, at least professed to the court, that it was very unclear as to who had the right to otherwise determine what would have been a safe discharge for him. And there was a very real question about whether, given his financial circumstances, he shouldn't be returned to his home and/or assisted living, correct?
That's correct, Your Honor.
So why would that form the basis for removal of the guardian at that time?
Well, I think if you look carefully at the February 1st, 2022 hearing, Justice Sharp was very clear that the discharge planning was to be handled by Judy Mock as guardian. There were protestations on the record by Judy Mock, her representative at the time, that, well, we have two persons that have been charged with investigating the best plan for discharge from Edgar, whether it would be to assisted living or whether it would be to his home, to his apartment. And Justice Sharp was very clear to both Judy Mock's representative and the geriatric care manager's representative that she wanted a report from the guardian so that she could make a decision, she could order the discharge in a way that made her comfortable as the person who was ultimately in charge of making sure that Edgar Lowe is taken care of. That's the court that takes on that charge as the protector of Edgar Lowe.
So by that time, there was certainly bad relations between the special guardian and the guardian.
Sure, and those
There was a lot of conflict, right?
There were bad relations between the guardian and the special guardian that occurred about 6 months after the special guardian was appointed. The special guardian was appointed in August of 2021. When the special guardian started asking questions and started taking actions that the guardian did not like, there became conflict.
So, but as concerns the discharge, what about the discharge that ultimately happened justified removal?
The removal...
Because that was why she removed the guardian and the attorney. It had to do with the discharge.
I think it was also cumulative, Your Honor. At that point, at the point of the removal of both Gary Elias as counsel and Judy Mock as the guardian, there had been a motion to remove the guardian for cause and a cross motion for declaratory judgment determining that the hundreds of thousands of dollars of distributions to Rashida Nashiri from Edgar's estate by Judy Mock were improper. That motion was opposed by both Judy Mock and Gary Elias, and the judge had all of those papers in front of her. The facts...
Well, she didn't. She had a different return date, though, on that motion, didn't she?
She did. She did, but...
it was a return date after she removed the guardian and the attorney.
That's correct. The only papers that could conceivably be submitted after the motions and opposition were the special guardian's reply papers. So the judge had a record before her upon which to make a determination, having given Mr. Elias and Ms. Mock a notice and opportunity to be heard on the issue of removal.
Did it require a hearing?
It does not require a hearing.
Why not?
The statute 81.35 says that the discretion to remove a guardian should be made upon a motion, okay? There's no requirement of a hearing. Furthermore, this court...
If there were disputed facts that were raised, should there have been a testimonial hearing?
So, and that's the thing here, Judge. The facts that should control the outcome of this appeal are undisputed. Okay, Judy Mock represented to the trial court on 3 separate occasions that no bond was required in this case. A bond is required in order to protect the guardian, and the amount was held in abeyance pending the initial report.
Well, I had to figure out what the estate was worth before the court set an amount.
Right, and she had
But
marshaled...
that, I look at, a bond was ultimately posted, correct?
2.5 years after Ms. Mock took her post.
I suppose, and I honestly don't know the answer to this, that if in fact, because we don't know, because we don't even have a disposition on the accountings yet, and that wasn't the basis for removal, that if there are things that need to be surcharged, I don't know if the after-acquired bond would even cover it.
It does not.
I don't know what would be in the guardian's interest in not getting a bond in an estate of this amount. It is a little befuddling to me.
She had a fiduciary obligation to let the court know that she was required to be bonded and to ask the court to set the amount. And Gary Elias, who is supposed to be representing Edgar, where is he when she's representing to the court that no bond is required?
Yeah, Gary Elias, now let me ask you about this, because this is a head scratcher to me on this too. He came in on the original order to show cause because the AIP is entitled to representation before you put in the guardian, right?
That's correct.
And he fulfilled that obligation, but the court kept him on. Are we clear what his duties were?
I'm not clear, Your Honor, but if I can submit that my belief is that Justice Kennedy fully expected Judy Mock to discharge her duty to conduct the investigation, that you're right, she clearly said she did not into the bona fides of the marriage and the financial transactions that were taking place around the time of the marriage.
Mr. Elias, was he or was he not Judy Mock's attorney once a guardian had been appointed?
I do not believe that he was Judy Mock's attorney. My belief is that he is Edgar Lowe's attorney.
And Judge Kennedy, she did give him a specific task, right? Which was to kind of be in touch with him and try and work out visitation, if at all possible, with your client.
That was what, you're correct, Your Honor.
So what else was he required to do, and why would he get discharged? Because there was a problem related to the discharge from Lenox Hill Hospital, and or if we could go there, the failure to investigate what seemed like pretty, significant claims that maybe Mr. Lowe had no capacity to enter into the prenup and marriage that he did.
I think that's a valid question, and I think the answer is, in terms of what the issue is with Mr. Elias,
right,
is that he had these obligations to Edgar as Edgar's lawyer, and he did nothing. He did nothing about the bond. He did nothing about the hundreds of thousands of dollars that were distributed to Ms. Nasiri outside of any authority from the guardian. If there are going to be gratuitous transfers, the mental hygiene law has a whole section that's dedicated to making gratuitous transfers. So if there are going to be gifts or transfers without consideration to Ms. Nasiri, 8121C has a whole procedure that the guardian has to go through. She did not have...
Well, it wasn't the monies that were made, for the most part, were made pursuant to contracts. No?
No, Your Honor.
The service contract?
That service contract expired in February of 2019. Let's forget about, on its face, it expired in February 2019. Ms. Mock told the court in June of 2021 that she had the authority to distribute. She said, the order specifically states that I have the authority to distribute $12,000 a month to Rashida Nasiri, the 1st and 15th of the month. She had no such power under the order in judgment. She made it up out of whole cloth at that moment. The personal services agreement that I think you're referring to on its face expired in February 2019.
Okay, thank you. Let's hear rebuttal.
Thank you.
Go ahead.
Thank you, Your Honor. Listen, I've been doing this long enough to realize that I'm not going to read into questions, but I do have to make sure that the record is clear about the facts. So if you allow me, I'm going to go very quickly, but there's been a lot of things that have said that are inconsistent.
You know, I've been giving you all a lot of time beyond the 3 minutes that I gave you. So, and rather than taking up time, asking me for more time, use your time wisely, sir.
Thank you, Your Honor. First and foremost, the bond has to be set by the court. The reason why Ms. Mock didn't have a bond is it was never set by the court. It wasn't set by Judge
You know
Sharp.
what, I can't say that I buy that. You know why? Because the order said that it was going to be held in abeyance until the court had further information about the nature or the assets. And it was Judy Mock's responsibility to come to the court and say, hey, Judge, this is a $35 million estate. We need a bond here. And quite frankly, I am, again, scratching my head. Why on earth this woman wouldn't, meaning your client, wouldn't have wanted a bond?
But she did want,
Let me finish. To protect her, in the event that she was surcharged for something weird that she did.
She did want a bond. She filed accounting. She filed 2 accountings requesting a bond. The court didn't do it. So it's clear.
She could have pushed the issue, and it was in her interest, and it wasn't in the estate's interest.
And I would argue she did what she was supposed to do according to the law, and the court did not. I'm also going to make clear, Your Honor, that the order appointing guardian did not require her to look into the marriage. What the judge said, Judge Kennedy said, it's in one of the transcripts.
Well, that order didn't, but the court evaluator's report raised that issue. And it seems to me that would put the guardian on notice that this is an issue that the court will want to know about. Wouldn't that be, I mean, why wouldn't that have been enough to put your client on notice that this is something that she should give some thought and do some investigation about?
And she did.
And in what form did she do that?
The issue, she had conversations with Dr. Bruno. She had conversations with the attorney that represented Edgar prior to the appointment of the guardianship.
Then why did she represent to the court when when one of the motions was made for a court evaluator to conduct an investigation, that she did not do any investigation? She was actually said that she had no obligation to investigate, and she didn't do it. And she right out said it.
My interpretation of that is this, Your Honor, that she had the relationship with Edgar, she had the relationship with other individuals. Edgar was stable. Before this guardian started, Edgar was in deep distress. He could have died. She took action to make sure he was safe, and everything was fine. She knew that there was a relationship between Rashida that was very, very important. She made a fundamental decision that given the fact of all the wealth that Edgar had, the issue of the money was paid to Rashida, which was limited and also consistent with a prenup, which was limited, did not require.
I don't really understand this, quite frankly, because this was a man who clearly had capacity issues, and the prenup was made in close temporal proximity to the time that these cognitive problems were being brought to the forefront. I mean, at the hearing in front of Judge Kennedy, he didn't even know that Ms. Mock wasn't his wife. He couldn't identify the judge. He didn't know he had gone down to be married in front of the court. You mean to tell me that didn't put the guardian on some kind of notice? Oh, maybe I ought to look into this seriously? Really?
You know, listen, when you're dealing with somebody who has incapacity doesn't mean that they're totally incapacitated. There are times when decisions are made. The decision in terms of the marriage and everything was months before the ultimate finding by Judge Kennedy that Edgar required a guardian. There was Dr. Bruno, the geriatric care manager, other individuals who were involved in this case made it very clear that there were times that Edgar clearly did have capacity to make decisions. He's a live human being. The decision that Judy made was in consultation with Edgar and the other professionals, and she made a decision.
But counsel, how do you, yeah, that's what I'm,
Just
counsel,
not
let
in
me
the
just,
record.
there's nothing, what she says in the record is not that. What she says is, I didn't have an obligation to do that. Not that I did this investigation, here's who I spoke to, here's who I spoke to.
When
why
she-
I concluded.
We are bound by the record that you all put in front of us, and that is not what the record said.
The record order appointing guardian did not require her to go and take any action against the marriage of Rashida, and it was very clear that she made a decision as a guardian to do what she thought was best for Edgar, who she represented, to put that burden on her right now when Edgar was safe and stable for the first time since the commencement of the
maybe
guardianship.
subject to financial abuse, but okay, let's hear from Mr. Elias's attorney on
Thank you.
rebuttal.
Thank you, judges.
2 points I'd like to make. One is to address some of the questions the bench had with respect to my client's affirmation. I believe he called numerous questions of fact to the court's attention requiring a hearing. He quotes...
Where?
Okay.
Where is it in the record?
Paragraph 9 in his
Record cite,
affidavit.
please. Record site,
May I
please.
read it out loud?
What?
You can, but you know, we have to go back to the record on
Yeah,
appeal.
this is the only
So
one
that
I-
doesn't really help me. If you give me the page number, then that is much more helpful.
I apologize, Your Honor, I don't have the record page number, but in his affirmation, he states that the special guardian alleges that I may be a witness because she admits there are, quote, significant issues of fact with respect to the agreement, whether or not the agreement was to expire or not. He also goes on in the next paragraph to say that it's a question of law as to whether or not the agreement expired or not.
So what questions of
Well,
fact
so
does
what-
that raise? I
sorry.
didn't hear any questions of fact in there.
He says, furthermore, special guardian's petition makes statements, quote, many of which are false, that claims to be facts without supporting it, without any support of evidence or testimony.
Right, but if he doesn't dispute any of them specifically, it doesn't create a question of fact.
Just so I know, so we can get back to it, the affirmation that you're referring to is the affirmation that he put in response to the motion by the special guardian to have him removed.
Correct.
Okay, all right, so now I know where to find that. Thank you.
My apologies for not having the
No,
record
that's
page,
okay,
Your
I'll
Honor.
find it. Thank you.
Of course, I had record pages of other questions that you didn't ask. One last point I want to make is that should Your Honors decide to send it back for hearing under the matter of Gordon, where there was a question as to whether or not a second guardian should be appointed, and there was no hearing, and the lower court determined that a second guardian should be appointed, the court sent it back for a hearing, and this court sent it back for a hearing, and not only did they send it back for a hearing, they sent it back to a different judge because they determined that the Supreme Court should not have predetermined prior to holding the hearing that another guardian was required. So I am asking that if the court should send it back to a hearing, it goes back to a different justice because this justice has already predetermined that my client should be relieved. Thank you.
Thank you.
If it please the court. The simple fact is this. The interests which you need to determine whose interests you're trying to protect is the incapacitated person, Edgar. The fact of the matter is Judy Mock and Gary Elias both communicated with Edgar concerning what his wishes were. You were told that the money that Ms. Mock...
If Mr. Lowe was incompetent, what part do his wishes play in a financial decision that could affect him to the tune of $10 million?
Your Honor, there was no financial decision that pertained to $10 million.
What about the prenup?
I'm sorry.
What about the prenuptial agreement? That affected immediately $10 million being moved from him to Rashida, right?
No, what it affected was upon a divorce or a separation between them that would have occurred. But the fact of the matter is that the attorney who prepared the prenup was an attorney representing Mr. Lowe, And that attorney, who there is no question about this, and it was also in our papers in the lower court, that attorney had extreme experience in preparing prenups and evaluated, or would have had to evaluate as an ethical duty, as to whether Mr. Lowe had capacity to sign that agreement. The problem is this. Everybody is making the assumption that because Mr. Lowe was designated an IP, he was necessarily incompetent or incapable of making decisions concerning other issues at different points in time.
No, I think that that's an incorrect argument. All we are questioning about is whether, given this set of facts, that the guardian shouldn't have done a more appropriate investigation about whether that what you say is true or not. And so it's really something fundamentally different. Okay, all right, we understand your arguments.
Your Honor, may I just make one more point? You have hit the nail on the head. But the only way to know that issue is to have a hearing as to what happened. And there has been no hearing.
Okay, understood. Understood. Thank you. Thank you, gentlemen, for what is one of our more difficult cases today. Yeah. Okay, the next case up is Alesco Preferred versus ACP. I am recused on that, and Judge Kern will be the judge in charge.
May it please the court, good afternoon. William Adams for defendant appellants. Supreme Court erred in allowing plaintiffs' claims to proceed against defendants other than the issuers. The indentures provide narrow circumstances in which plaintiffs can swap out for the issuer for a different counterparty. And the complaint simply does not allege any of those circumstances in this case. Turning to the first causes of action, none of the transactions that were at issue in the amended complaint trigger the successor obligor clauses. That first amended complaint, the first claim is for failure to pay the...
Let's get to what seems to be one of the primary issues. The language used is the surviving corporation. Is the issuer the surviving corporation? Not, did it survive? So why is that not ambiguous to some degree, what that means by the surviving corporation, and whether or not the issuer actually did survive these two transactions?
Sure, Your Honor. I think it's essentially plaintiffs have pled themselves out of a breach of contract claim under the plain language of the indentures, because with respect to the Canopius purchase transaction, if you look to paragraph 82 of the complaint, which is at R479, the plaintiffs expressly allege that the issuer survived the transaction.
Right, but that's why I particularly asking you to address the language, the surviving corporation. Is it enough to survive in name only? And is that something that we can resolve in a motion to dismiss? Because if that was the case, that all they had to do was legally survive one way or another, then you could do basically a sham transaction where they have no assets left, but they're surviving, and that would obviate any further obligation.
They're more than surviving in name only, Your Honor. They still have the same assets that they did at the outset of the transaction. There's no allegation that there's been any dissipation or disposition of their sole assets, which were the underlying insurance companies. So this is not a circumstance where there is a allegation of a sham transaction where...
It's also not a circumstance where they are the only corporation left at that point. There's another entity involved in the picture now. The circumstances have changed.
Sure, with these transactions, there are certainly other entities that have become involved, but the sole successor obligation clauses are really concerned solely about whether there's a counterparty left. And it's intended, this is 11.1 of the transaction, it's intended to make sure that the plaintiffs, the investors, are always able to go out and go after and try to recoup assets and their investment from a party. And so if there's a situation where the issuer is no longer, it substantially dissipates all of its assets, or it no longer exists, or something like that, that's exactly what this transaction, or that's exactly what 11.1 is intended to do. But there's nothing in the complaint that alleges that the issuers are no longer in existence, that the issuers no longer have the insurance companies as their assets, and that's what the plain language of the agreement is intended to prevent, and there's simply no allegation. I spoke about the Canopius transaction, that was paragraph 82. It's also the same with respect to the ACP purchase transaction. It's at paragraph 143, that's R497.
Wait, let me, isn't it, didn't TGI dispose of its assets in the transaction?
Your Honor, in none of the transactions did TGI...
Isn't that the allegation? I mean, this is a pre-answer motion to dismiss. You might win on summary judgment. Isn't the allegation that TGI disposed of substantially all its assets in the transaction?
The allegations, Your Honor, do not, the complaint, Your Honor, does not allege that anything with respect to the underlying assets of the insurance companies.
No, we're talking about the corporation. So you're saying it survived, but there is an allegation that TGI disposed of substantial, I mean, I read it, so I know it's there. So the question then becomes, on a pre-answer motion to dismiss, without any discovery, and without knowing whether or not that the way that the transaction was structured was to ensure that these holders would not be able to collect. I mean, that's what the purpose of that whole thing. The purpose is to ensure that if I buy these, there's going to be somebody left for me to collect from.
Well, Your Honor, they could have drafted a much broader agreement. They could have drafted an agreement that was concerned...
Again, we are talking about a pre-answer motion to dismiss.
I absolutely agree with Your Honor, but I'm looking at the plain language. There's no record development that needs to be required to apply the plain language of the indenture to the allegations.
So what about, in addition to what my colleague said, what about the TGIL proxy statement, which states that TGIL was deemed a successor of TGI pursuant to 129.3 of the Securities Exchange Act? Isn't that at least enough to allow this case to go forward, even if it's not dispositive, as to the issue of whether TGI really was a surviving corporation at the end of this transaction?
Okay. So that is, Your Honor, that's just with respect to the Canopius purchase, not the other transactions that are at issue.
Well, that's what we're talking about now. We're not talking about...
No, I agree. I agree. Just to be clear. But no, Your Honor. Supreme Court wrongly relied on that SEC filing because the statement, and that's it. If you look at R1747 and R1760. The statements that the Supreme Court was relying on was simply that TGIL said it was a successor to TGI as registrant under those SEC rules. It doesn't say that it's a successor for purposes of its corporate debt.
Yeah, but that's to support the claim that it's not clear for purposes of a motion to dismiss that it's not a successor corporation and that TGI is no longer responsible under the indentures.
But the allegation in the complaint, which is solely in paragraph 83, only refers to that specific SEC rule, and that SEC rule is talking about registration of securities. Only one company can be the registrant company under the SEC rules. That's different and distinct from whether it assumed the corporate debt under the indenture.
But isn't it enough to create an ambiguity as to who's a surviving corporation?
I respectfully disagree, Your Honor. I think that it's a specific rule that's intended for a specific context, and it's different than the plain language of the indenture. Do you have any more questions?
Or? Okay, thank you.
Okay, thank you.
We have time for rebuttal.
May it please the Court, Timothy DeLange from Wilmoth, Marr, and Deutsch on behalf of the respondents. I want to get to the solely corporate obligation clauses and address a couple of the questions. But the first thing I do want to do is I want to put this in context. The Trupps are clearly in default. They have been in default. Plaintiffs have a breach of contract claim against the issuers. Justice Borak found that plaintiffs' allegations of successor liability, alter ego, while they're not independent causes of action, they are theories of liability and that our allegations are sufficient. That's not on appeal. They did not appeal that in the opening brief.
So you're saying you win no matter what with a breach of contract?
Essentially, what I'm saying is
Because
yes.
they've waived the claims as to alter ego.
And to be perfectly clear, we're on a motion to dismiss. We don't win, we win now. The facts can be developed, we can move forward. If they want to challenge what happened in each one of these transactions, they can do so on a full factual record. So we're going forward no matter what. We're going forward with the successor liability, the successor obligations. What I do want to...
Then, let me focus on you. I know we talked a lot about the first cause of action for breach of contract, but what about the second cause of action for breach of contract? Why should that claim survive?
That claim should survive, Your Honor. That claim is a breach of Section 3.8 of the indentures, which says that you cannot make a distribution or a dividend payment while the trusts are in default or while the interest payments are being deferred.
Isn't it undisputed under the record we have before us now that there actually was mutual consideration for that exchange, that it was not a one-way exchange, which would take it out of the language of the clause?
Are you saying that there was a mutual exchange for the $143 million payment that went to the shareholders for stock that was worthless? Because I disagree with that. I don't think I think that's our allegation, is that there was not mutual consideration, that money was taken that otherwise would have been available to the issuers to repay the trusts, and it was essentially taken and provided as consideration, almost as a quid pro quo, to enable the merger to go through and allow the shareholders to receive an equity payment that they're not otherwise entitled to on worthless stock. That's what our allegation is. I don't believe that the allegation is that there was adequate consideration.
Okay. Go ahead.
And what I want to move on to is the very last point. We think Justice Borak did an excellent job, except for one minor issue on the solely corporate obligations clause. We've briefed it. I just want to highlight it. He read into that clause that it was an exculpatory clause.
No, we didn't. That clause is as broad can be. We've seen them 100 times. This is no different. So I am sorry. He did not read something into it that wasn't there. This is exactly what every corporation does in this circumstance, and I disagree that he read something into the clause. Because this is a standard clause.
I agree with you. It is very standard. And if you read the clause, it is referring to future officers and directors. It is providing them protection. It does not apply to future conduct that is willful, grossly negligent, or fraudulent. And that is the distinction here, because we are alleging that conduct. If it was simply negligence, then I would agree with you, Your Honor.
So when this, I printed it, and it says, any claim, because that's exactly what happens, right? If you say, you can't get, I'm not going to pay back, then you twist it into a tort claim. Then if it's not a good tort claim, you twist it into an intentional tort claim. So when someone says any claim, that means any claim, right? That's what it says. Any claim that has to do with these debentures.
That is what it says. I agree with that.
Says, right?
Yes. Yes, it does.
All right. Thank you.
My last comment would be to apply that to future willful, fraudulent misconduct violates New York law and the principles, because it essentially gives them freedom to do whatever they want to, and that's not consistent with the law. Unless there are any further questions, I have nothing further.
Thank you.
On the first cause of action, the successor and alter ego theories, we didn't waive that. That's an alternative ground for affirmance. Justice Borak did not rely on that to sustain the first cause of action.
No, but can you address the second cause of action, actually?
Sure, the second cause of action, that solely concerns the reinsurance and renewal rights agreements. And the question was absolutely correct that there was a reciprocal and mutual exchange of consideration. That clause, the section 3.8, refers to dividends or distributions on the capital stock of the issuers or the insurance companies. And these payments under the reinsurance and renewal rights agreements are not dividends or distributions with respect to capital stock. And so that's dispositive of that claim, and I think they have pled themselves out of it.
So let me just ask you one more question. Neither party argues that this new iteration of the complaint is violative of the California's injunction, correct? Everyone agrees that this can go forward, but however we look at it, but there's nothing that either party raised about the California court's injunction.
No, Your Honor, we do think that counts 2 and counts 3 through 7, to the extent that they implicate the renewal and reinsurance and renewal rights agreements, that does violate the California injunction because it concerns the propriety of those agreements which were approved by the California Insurance Commissioner and are really sort of second-guessing the management of the insurance.
But I don't think you appealed on 3 to 7, right? There was no...
It's the final point of our it's the final Roman numeral heading of our opening brief, Your Honor,
on the issue that it violates the California injunction?
Yes, Your Honor. Okay. And so we have narrowed our disagreement with the complaint over the course of the proceedings. But yes, no, that's preserved. That's preserved for appeal. And if I could just finally address the fraud claim, I do think that
one sentence, because your time is up.
Understood. It's a very broad exculpatory clause, and there's no public policy concerns here because they're essentially seeking contract damages. They've dressed up their contract claim as a fraud claim. Thank you, Your Honor.
State Farm is next.
Thank you. Should call the case? Yeah. Okay. Excellent.
I didn't set it.
Okay.
Good afternoon. My name is Thomas Torno. I represent Appellate State Farm. I'd ask the court to consider State Farm's argument that there is a question of fact with respect to the waiver of subrogation, in that it's our position that based on the terms of Section 9 of the lease, the waiver is limited to, quote, the demised premises. Subdivision A, B, C, and D, they all use the term if the demised premises, if the demised premises, if the demised premises. And then you go to the next sentence after all this, and I believe that this is the key to our position. It says, and it distinguishes this case from the other cases, such as CAF. The release and waiver herein referred to, so on and so forth, and/or to any personal property, equipment, and fixtures, goods, and merchandise, quote, located therein. That phrase, located therein, is what distinguishes this case from CAF, St. Paul's, the other cases that are cited, Greater New York, that the court cited below, and we say that there's a question of fact as to whether or not this waiver is limited to demised premises, and that it doesn't include non-demised areas of the premises. Now, in the defendant's initial motion for summary judgment, they submitted as part of their initial moving papers State Farm subrogation receipts, which showed that a substantial amount of the payments was for work not involving the demised premises. The lobby, the basement, some law office, as we point out in our brief, the demised premises is specifically defined in the lease, it's page record 14 of the lease, as, quote, the third floor, the entire third floor. It's our position that the position of the arguments of the respondent in effect seeks to rewrite Section 9 of the lease so as to provide that the waiver of subrogation applies to not only the demised premises, but to the non-demised premises as well. Unless the court has any questions, I'll rest on my brief for the remainder of our arguments.
So let me just ask you, when the agreement says the release and waiver herein shall be deemed to include any loss. And then it goes on to say, or damage to, right? Haven't we held that word or, that disjunctive or, means it doesn't have to just be in the demise premise? We've held that in other cases.
I don't think so. I don't think that the phrase demise premises is not in the language of the other cases. In the lease is that issue.
No, what is, though, is that disjunctive, which makes any loss mean any loss you suffer from this. That's what those cases stand for.
No.
I mean, if you had said any loss in the demise premise or damage to the demise premise, that might have been something else.
No,
Those cases say any loss. And then once you get to that or, then that first part means any loss.
No, I submit it means any loss to the demise premises.
No, because some of the cases are talking about business interruption loss. That can't be a loss to the demise premise.
Yeah, we're not claiming that. No, we're not claiming that.
I understand, but what I am saying that that first part, that any loss, has been held to, in more than one case, than to apply to, for example, business interruption, which is not a loss that is at all connected to the demise premise.
No,
and that's why the disjunctive is the problem.
No, my understanding, though, is those other cases, the leases do not have the language to the demise premises. That's what's missing. You look at the leading case, CAF, the Court of Appeals comes out and says it's conspicuously absent in that sentence is the phrase demise premises. The loss is an adjective that refers to the demise premises, not any loss, it's just inconsistent with the whole paragraph, the whole section.
Counsel, what about our decision in Crestvale International versus Reuters from 1999? Isn't that exactly on point?
No, I don't think so. The facts are different there. In that, firstly, the language of the lease is different than this language. And there's also a different type of a claim that was being asserted by the tenant against the landlord for something the landlord did outside the demise premises. The court held that under the terms of the lease, it's all covered by the waiver. I don't think it's covered, it applies to our case.
Okay, let's hear from your adversary. Thank you. Go ahead, Counselor.
Good afternoon, Justices. May it please the Court. As was argued and stated by this Court in the previous case, any claim means any claim, and in this case, any loss means any loss. The contract and the lease is absolutely clear. This case comes down to the word or. The contract says any losses or damage to the demise premises. Everything after the or is correctly stated by the appellant to involve certain parts of the building, but before that, it says any loss. And this is on all fours with Crestvale, this Court's determination in Crestvale. That word is a disjunctive, or, and you have to read everything before it broadly, and in this case, the plain meaning of the contract says any loss.
Also, wouldn't the term damage to the demise premises be included in any loss?
Yes, it would be. It would be. So it would be any loss, and it would include damages to the demise premises, and that's our position. In this case, there were damages inside the tenant space, and there were damages all over the rest of the building, as Appellant's counsel
Well, I guess my
mentioned.
point is that if it means the same, why include both? When one clearly is trying to limit it to the demise premises.
Well, I think if it was intending to limit it, it would use terms like limited to, expressly limited to, restricted to. Those words are not included in the lease. Those words are included in Appellant's brief, but they're nowhere in the lease, and they're nowhere in the cases cited in our brief. And I think in the case of Greater New York Mutual Insurance Co. versus Nahir, 2017 New York County case, an identical waiver provision was interpreted, and the court found, interpreting Crestvale and CAF, that any loss means any loss, and there is no limitation whether the fire or the water caused damage in the tenant space or outside of it. The point was that the parties intended to take care of that risk through their insurance, through their own insurance, and not through costly litigation. And ultimately, I think in these cases, the question comes down to what is the relationship between the landlord and the tenant? Here, that relationship was based on this lease to identify their decision on how to manage risk in this building. So I believe the trial court had it absolutely right. I'll give up the rest of my time and rest on the papers.
Thank you. Rebuttal?
Just briefly, Your Honors, in Creswell, it did not involve the issue of the waiver of whether the waiver of subrogation was limited to the demise premises. In fact, the lease specifically provided that each party waive subrogation for any loss or damage to its property or the property of others resulting from a fire or other hazard. Here, in contrast, the waiver is limited to the demise premises. If the phrase any loss or damage, it's got to be to the demise premises. Otherwise, it negates the second part of that sentence. There's no need to have the phrase demise premises in there, and you shouldn't just ignore it.
Well, on the other hand, it could mean, or it sound, the way to make both sections is, because it doesn't say loss, it says damage, right? When you're talking about damage to the demise premises, that's different from a loss from the fire. So that would make both sentences, both clauses jibe, right? Any loss, or in terms of the demise premises, damage. That would be consonant with both parts of the or making sense.
I still maintain it's any loss to the demise premises. You know, then you read the rest of the sentence.
But it says any damage to the demise premises, right? Not loss, damage.
And then it goes on to say personal property, etc., located therein. That's another phrase that's not in any of these other cases, located therein. This lease was carefully drafted. You can see, by the way, they kept using the word demise premises over and over and over again in just Section 9 alone. So, thank you.
Thank you. Thank you both. The next case for argument is Manglani versus City of New York and Elkham. You can proceed.
Your Honor, may it please the court, Jody Bernard, Hickey Smith Dodd for the appellant. This appeal is taken from that part of the lower court's order that found that the affidavit submitted by the defendant did not prove conclusively that there was no cause of action as required by CPLR 3211. We believe, of course, that the affidavit did in fact satisfy that requirement, and specifically the lower court stated that it did not contain sufficient detail on whether or not Elkham had done any work in the tree pit. And
Counsel, don't we have a legion of cases that state that an affidavit is not documentary evidence which would support a motion to dismiss on the ground of documentary evidence? It's not enough just to state something in an affidavit and say, it is so, that's why we have motions for summary judgment. If you made a summary judgment motion and you stated that, and they didn't come up with anything, then you'd win. But this is a motion to dismiss on documentary evidence, and we don't necessarily take the affidavits as true. So how do you get around that?
In fact, the lower court, Judge Ramsord, cited to the case that says that unless you can prove that there was no cause of action, the affidavit actually shows enough of the elements to say that there could be no cause of action. And I believe we have met that threshold by this affidavit, which, for want of a better term, would be equivalent to a Jackson affidavit in a discovery proceeding. It talked about what was searched, what was, where they looked, the course of action. All of that comprehensive information was in this affidavit.
Did you annex the documents that you were referring to in the affidavit?
There was no, they found nothing. There was nothing to annex.
So where's document?
No, right. The affidavit says, I looked at our files, and as I looked at our files, we didn't do any work on the tree well. That's basically what the affidavit said, correct? Yes, you put in the deed, but you didn't put in your files. Nobody except you have looked at your files. So we're not really, so I guess the point is, so we are to say, sure, we believe you without having a deposition of you, without telling you what files you did and did look at. I mean, I read the affidavit probably an hour ago, and all your managing agent says is, based on my review of our records, we did no work in that tree well. That's basically that's literally what she said. But I don't know what, she doesn't say how they keep their records, who keeps the records, what records she looked at. Nobody got an opportunity to talk to her about the records. You see where I'm going with this?
I do, Your Honor, and I believe it was a little broader in scope, having worked there for 23 years and knowing what the course of their behavior is, and it also speaks to that because, as we know, the tree well is a special piece of New York City sidewalk legend, and because of that, she was able to go this step further and say, we don't touch those tree wells because we know what the city is responsible for.
And I accept that's what she said, but this is the question. You moved on documentary evidence, on a motion to dismiss. It sounds like a summary judgment motion, but it wasn't a summary judgment motion. So affidavits, only in rare circumstances, can serve as documentary evidence, warrant dismissal, or issues of law do. Sure, certainly the issue of law regarding what the duty is with respect to tree wells, it's not the same duty as under the administrative code for the sidewalk, but there's still potential liability for cause and create. So how is this documentary evidence that would otherwise warrant the pleading not surviving a motion to dismiss? I think that's what we're grappling with here.
So, Your Honor, I did move under 3211A1, which is failure to state a cause of action, and I do believe that that standard is a little different, and there's case law.
But they clearly state a cause of action. The cause of action is that you are responsible for the tree well outside of your property because you caused and created the condition. That's a cause of action.
But there isn't that. The pleadings do not say that, Your Honor. They just say that you're responsible for the tree well. And I believe because there is case law that says you shouldn't put such a narrow view on 3211A1, that if I've come forward with evidence that says that they can't impossibly prove this, there is no cause of action.
Oh, that's kind of a difficult proposition. But okay, let's hear from your adversaries.
May it please the court. Good afternoon, your justices. Raymond Macera for plaintiff respondent Manglani. I will disagree with counsel. The complaint clearly set out a cause of action at paragraph 23 with regard to cause and create of the defect at the tree bed. The affidavit.
So, and wasn't there some kind of ticket given to the landlord about some problem at the tree bed?
Miraculously did not find any of those violations which were right adjacent to this tree bed. The city came forward with that. It was still pre-discovery. They refused to go forward with discovery, so we haven't had a chance to depose anyone, to get any further information. But there clearly is that. We clearly state a cause of action. There is no document utterly refuting the case or the claims were made. It must be denied. It's completely, they have not met their burden under 3211. They could have made a summary judgment motion, they didn't, and they haven't met their burden under the statute. If no one has any further questions.
Any questions? No. Thank you.
Thank you.
All right, let's hear from the city.
Good afternoon, Your Honors. May it please the court. Jeremy Pepper for the City of New York. I'm just going to make 2 quick points. First, at this very early stage of litigation, I would posit that LCAM has not conclusively shown that this incident was solely caused by the tree well. I've worked on many trip and fall accidents, and oftentimes it's partially one thing, partially another. they cite to marked photos, but they don't attach them to their motions. They're not part of this record. We can't see exactly where it was marked. Furthermore, the only testimony we have is the 50H testimony of the son, who wasn't there when it happened. The plaintiff, unfortunately, has passed away. There's a known eyewitness, the wife, who has not yet been deposed, and she would be better suited to speak to where this incident happened exactly. The second point is, as Your Honor mentioned briefly, there were notices of violations issued for both cracked and raised sidewalks in close proximity to the tree well at issue here. And as the Court of Appeals has held, a defect that's left unresolved can be the proximate cause of a separate additional defect. And I would posit at this early stage of litigation, we just don't know whether or not that is the case here. As Elkheim has not conclusively shown at this early stage of litigation that they're not responsible for the plaintiff's incident, the below order should be affirmed. And if there are no further questions, I'll rest on my brief.
Anything further?
Thank you.
Rebuttal?
Your Honor, the violation, the last page of the exhibit, shows that it was never delivered to my client. It was sent to the wrong address, and it was never delivered. So to use that violation as anything that's dispositive in this action, I believe is, or to discredit the affidavit.
I was going to say, they're not using it as dispositive. You're
sorry.
the one who's asking us to make a dispositive adjudication.
I do apologize.
No, you don't have to apologize.
That it would discredit what's in the affidavit is not correct, because we did not get it. It couldn't have been in the file. Number two, it is a sidewalk violation. It is not a tree pit violation. The city ordered them to replace the sidewalk, not to do any construction on the tree pit. And last but not least,
Let me just ask you,
Sure.
I didn't see the photographs in the record. You didn't put them in, did you?
It was not in there, Your Honor, correct.
So when she says it wasn't in the tree well, based on the photographs at the 50H hearing, there's no proof in those photographs aren't attached to her affidavit, right?
No, but the language by the
And counsel, she also refers to having reviewed documents, but there are no other documents attached to her affidavit which she claims to have reviewed, except for things like the notice of claim and things like that. There's no underlying documents as to inspections or anything like that, right?
No, the documents she reviewed were the pleadings that I provided, and I thought, I think it was spelled out. And the only thing that would not have been in there is the photograph. Yes, that is correct. And the last thing, Your Honor, is the issue of the wife, which was raised on appeal for the first time, I don't believe is proper to bring that up to say now all of a sudden to create this issue on appeal. The rest of it will be rest on my brief.
Thank you. Thank you, counselors. Duricchio against Maidman?
1 minute.
1 minute.
50 seconds. I like this man.
Good afternoon, Your Honors. Joshua Horowitz on behalf of the defendant appellants. This is an appeal from the lower court's denial of a motion to dismiss on a 3211 motion to dismiss. It is abundantly clear that the lower court misapprehended the law in rendering its decision. It is clear from looking at the record on pages 14 and 15 in which the lower court stated that the standard is the same whether claims are posted on Facebook, in a broadside hung on a fence, or printed in a local newspaper. That statement by the court is in direct contravention with this court's holding in multiple prior decisions, which recognize clearly that internet speech, in fact, the standard is different in internet speech than it would be in these other contexts.
Yeah, this was an online review, right?
Correct.
Right.
And
an anonymous one.
It was posted anonymously.
Right, sort of mixed opinion, mixed fact? Yes, no?
Yes, it is a matter of opinion, and I think that's very clear from looking at the language of the review, that it is a matter of opinion. It's not an actionable statement of fact. An actionable statement of fact. It is not defamatory, and the lower court should have dismissed on that basis. And unless Your Honors have any questions, I rest on the brief and record as submitted.
Thank you. Any questions? No. We're good, thank you.
Thank you, Your Honors.
People versus Lopez? You can proceed.
Good afternoon, and may it please the court. Hannah Zakir from Debevoise and Plimpton, in association with the Office of the Appellate Defender, on behalf of defendant appellant Mr. Lopez. Mr. Lopez's due process rights were violated when he entered an unknowing, involuntary, and unintelligent guilty plea because the court failed to inform him of the mandatory term of post-release supervision he would be required.
There was a Cat 2 error, right? That's
Yes,
what
Your
we
Honor.
call it. I'm just shortening it so you could use your time more efficiently, because the question, I guess, that we have is so many years later and so many litigations or criminal proceedings later, why wasn't there otherwise a waiver of the Cat 2 error, certainly upon resentencing, and then in being sentenced for another offense where he said no constitutional infirmity?
Well, first, Your Honor, respondent already argued the waiver issue on the motion to dismiss. It was considered and denied by a panel of this court, and we don't think respondent should be given a second bite at the apple to litigate an issue already decided by this panel. We think it's law of the case. In addition, Your Honor, we unfortunately don't have the...
I'm confused. So didn't the court hold in the second criminal proceeding that the Cat 2 argument's basically been waived? That same argument you're making now was already raised in challenging the 2015 conviction, and we said, sorry, we're not accepting that argument. So why should you get a second chance to make the same argument the court's already rejected?
Your Honor, ultimately in the proceedings in the 2015 proceedings, what the court ultimately said there is if you go back on the direct...
Ultimately what?
What the court ultimately said for the 2015 criminal conviction is this is on a collateral attack. If you go back and appeal on direct appeal and put it before the court on direct appeal, then we can go back. He would have the opportunity then to go back to the collateral.
That is not what the appellate division said in the appeal, right?
Ultimately, I think, Your Honor, in the 2015...
Right. But let me ask you, on appeal, right, this court said on that 2015 claim, right, in which he said the same exact thing that you're saying here, my 2001 conviction cannot be used as a second, as a prior felony because it was taken in violation. And then we said in that appeal that you cannot raise that now below your client, the court, your client's lawyer said this is good, no constitutional violation, correct?
Yes, but Your Honor, the court...
And so now, we've said that already once. Is that not correct?
The court did say that if defendant attempts to appeal the 2001 conviction and survives the motion to dismiss, which in fact has happened in this case because the court here denied respondent's motion to dismiss.
As untimely. As untimely.
But the court continued that he's free to raise the CATU and resentencing claims before the appellate division on direct appeal here. And that is what the appellate division...
I looked at our order on that motion. Our order on that motion said, perfect your appeal for the September term and the motion is otherwise denied. That's it. So whatever you're talking about now, you are reading into what we said, correct?
Yes, what I'm referring to now is the court's order. It's actually in footnote 4 in respondent's brief, for the court reason that if the defendant wants to go and attempt to appeal the 2000 conviction, he's free to raise the COTU claims before the appellate division in the 2001 appeal, which is precisely what we're doing here.
Wait a second, in what decision is that? Where is that?
That is actually, if you look in actually respondent's brief, page 8, footnote 4, it quotes that ruling from the court.
From which court, though?
From the trial court.
That is from the appellate division in the, from the 2015 conviction from the 440 motion.
Oh, from the 440, I'm talking about the direct appeal.
Yes, so in the direct.
So on the direct appeal, right, we said, you've raised this issue before, exactly what you're saying now, we are saying, I am saying, you raised it in the 2015 appeal too.
If I could just read from that decision, what the court said was, at sentencing, defense counsel expressly stated that he did not see any constitutional defect in the prior conviction and waived any challenge to the defendant's predicate felony status. That waiver is
Well, Your Honor, I do think there's a difference between if I may proceed, I see the light is red.
You can answer the question.
There is a difference between a collateral proceeding where they're just attacking the sentence and didn't have the opportunity to actually seek to vacate the plea because it was in a collateral proceeding, and now that we're in an appeal of the 2001 conviction, Mr. Lopez has the opportunity only here to actually vacate the conviction.
That may be an interesting argument, but the language that my colleague just read to you talked about the waiver being binding. That's a substantive decision, isn't it?
It is, Your Honor, but we think that this is a really, just to finish off, a fundamental error in Mr. Lopez's guilty plea. It's a constitutional error, and we think the court should still consider it.
Okay. Thank you.
Good afternoon, Your Honors, and may it please the court, Noah Shamwoy for the people. Your Honors, it's rare that—
Counsel, in the first case, it's clear that the portion of the sentence, post-release supervision was not included. Does that not require reversal?
It does not, Your Honor. Now, as I'm saying, it is rare that we come before this court with so many different theories and bases for affirmance. In this instance, there is the fact that the case is now 22 years old, 14 years of which the defendant sat on his hands doing nothing and has no excuse for it. We have the fact that he did not file a notice of appeal from the resentencing, and consequently, even though the challenge that's actually being presented before this court goes to whether that resentencing was valid or not, there's no notice of appeal that actually presents that claim to this court. Now, the defense points to the fact that this court may, in its discretion in the interest of justice, overlook that mistake, but this is not a defendant for whom the interest of justice would ever be served. The crime in this case was particularly violent. It was an armed robbery with a gun, in which the victim was shot by the co-defendant in that case. The 17-year sentence he's currently serving is because of an armed home invasion with a gun of a mother and 2 children. He also has 21 felony arrests. 17 of those 17 became misdemeanor convictions, and he has 5 felony convictions. He spent the majority of his life in prison, and he is now seeking to have his current sentence vacated, which is the sole reason why this appeal has been taken. He has repeatedly said throughout the litigation history himself that he had no interest up until today in having his plea from 2001, this case, vacated. And so we have a situation with the defendant who, as this court has noted, has continuously waived any potential claim. Now, we also have the fact that it's unreviewable. The 2008 minutes are missing. The claim that's being raised is one for which the defense can absolutely waive it at the resentencing. He could say, I do not wish to have my plea back. He could consent to the resentencing. We do not know if that happened or not, and the fact that those minutes are missing because he waited an additional 7 years before seeking poor person relief is held against him. The fact that for the last 5 years, the defense has been aware with counsel that those minutes were missing and has never made an application for reconstruction is also under People v. Paris to be held against the defendant. So the missing minutes are essential, so it's unreviewable. We also know it's unpreserved because if the defense had preserved it, there would have been a motion to withdraw the plea, which would have been in writing and would have been in the court file, which he could have done but did not do. So we know it's also unpreserved, which People v. Williams says it must be preserved if the defense has the opportunity to preserve the claim. A Catu error must be preserved if he had the opportunity. And here in 2008, he was told, you're going to be resentenced, and for 4 months, actually not 4 months, excuse me, it was 2 months, over 3 adjournments, he never made any application. So it's also unpreserved, it's unreviewable without the minutes. We also point out that this is one of those few times when harmless error may even apply, because we have statements from the defendant saying, in effect, I didn't want my plea back in 2001. Well, that's pretty conclusive evidence that there was no harm done, which is not something Catu could possibly conceive of a defendant doing. So we have all of these different issues that have popped up, and the only one that's not in our brief that I even discovered in preparing for this oral argument is that at his sentencing in 2001, on the last page, defense counsel says, and I quote, "I have handed my client written notice of the right to appeal." The written notice, as this court is aware, is a document that contains the instructions on how to seek poor person relief. In fact, 2 years after that statement in People v. West, the Court of Appeals quoted from a written notice of appeal from the First Department, directly saying, to the same argument the defense is now making, that's totally belied by the record. The written notice says, this is how you take your appeal, this is how you seek poor person relief, and it's fully quoted in People v. West on page 27, 2 years after this opinion. 2 years after the sentencing in this case. So he received the very document that told him how to seek poor person relief. At sentencing, on page 6 of the sentencing minutes, the last thing that happened on the record, and his entire justification for 15-year delay of seeking poor person relief was he never knew, which we now know is wrong. And his entire defense of not getting those minutes in 2008 is because he didn't know about his right to poor person relief, which we now know is wrong. So that's the only additional argument I wanted to bring to the court's attention. If there are no further questions, please affirm.
Thank you.
Thank you.
Rebuttal?
Very briefly, Your Honor, in Respondent's briefing, Respondent speculates about what might have happened at the 2008 sentencing, whether he might have been given the opportunity to withdraw the plea or consented. We unfortunately don't know what happened at the 2008 sentencing, but we do know that those were very rote, pro forma, quickly done resentencing proceedings. There's no reason to assume that he was given the opportunity to withdraw the plea or there was consent. In fact, from the calendar calls...
Well, he was represented by counsel, though, at the resentencing, was he not?
He was represented by counsel.
So wouldn't counsel know to inform him about Catu errors at the time of the resentencing? I mean, it was a pretty well-known and very often litigated issue.
Counsel, he was represented by counsel. A counsel could have informed him by the error, but there's still, I think, no basis that he was offered the opportunity to withdraw his plea. And again, this is a...
But counsel, that also still doesn't answer the issue of his waiver at in 2015.
Again, I think because of the collateral proceeding, as opposed to being able to do it on direct appeal and actually vacate his plea, this is the first time he's had the opportunity to do that, to try to vindicate his constitutional right for...
Yeah, but he did raise it directly in the 2015 matter, so he can say, oh, I didn't have the right to do it, and since the court made a ruling that it was binding on me, I can't be bound by that? Really?
He did have the opportunity to argue about his sentence, but never really had the opportunity to directly vindicate his rights as to his plea, and that's what he's trying to do.
And that's what I'm questioning. It's like you're saying, gee, he had to raise it in a collateral proceeding, which might be right, but in fact, we addressed the issue on the direct appeal. Maybe we shouldn't have, but we did. But we did, and he raised it, otherwise we wouldn't have. So yes. I don't know why he gets to say, oh, I made a mistake. I shouldn't have brought it before you. I should now be given another opportunity to bring a collateral proceeding to otherwise protest it. I'm just not following.
Again, Your Honor, we still think he should have the opportunity to vindicate his constitutional right to a guilty plea that's invalid.
Okay, thank you.
Thank you.
Thank you for your pro bono service, and please thank your firm for us as well.
Thank you, Your Honor.
People versus Dukes. You may proceed.
May it please the court, good afternoon, Your Honors. Ashley Baxter for Appellant, Fuquan Dukes. Your Honors, Mr. Dukes' sentence to a 5-year term of probation is excessive in light of his age, lack of criminal history, and need for substance abuse and mental health services.
When does that term of probation end?
Next year, July, Your Honor.
Next July? Thank you.
Yes, Your Honor. So we argue that it's excessive and that it should be reduced to the 3-year statutory minimum. Sentencing Mr. Dukes to the maximum probationary term was harsh, again, Your Honor, in light of his age and lack of any prior criminal history. There is no penological reason why 3 years of probation would not be sufficient. In fact, Your Honor, the legislature recognizes
Also,
that.
when you say that it's harsh, I mean, he faced criminal possession of a weapon in the 2nd degree, right, which is a violent felony. Here, he was given the opportunity to plead guilty to criminal possession of a firearm. And not only was he given that opportunity, but then the minimum sentence, incarceratory sentence on that crime is 1 to 3 years with a maximum of 1 1/3 to 4. He received probation. How can we argue that it's harsh?
Well, Your Honor, we argue that it's harsh given that this was his first criminal arrest and his only conviction. Your Honor, we would also...
But he was stopped after riding a dirt bike, making people jump out the way, and then had a loaded gun. That's serious, right?
Yes, Your Honor. We argue that this, in light of the mitigating circumstances, his age, he was 27 years old at the time, his lack of any criminal history.
Well, I'm not sure which way the age cuts. It seems to me he's old enough to know that carrying a concealed loaded gun while riding a bike dangerously is not a good idea. I mean, it'd be one thing if you were 17 and you were say he didn't know better, but he's 28. Well, how can you say he didn't know better at that age?
Yes, Your Honor. We argued that, well, Your Honor, Mr. Dukes told probation, and in his statement of notice, he explained that he had the gun for protection, Your Honor. But we argued, Your Honor, that we also note that Mr. Dukes...
So is that an exception to the gun laws?
No, Your Honor. We just note that he explained why he had the weapon, and we also note that he's not alleged to have used the weapon to menace or harm anyone, Your Honor.
Counsel, why don't you address the validity of the waiver right to appeal?
Yes, Your Honor. So we argue that the waiver is invalid for a number of reasons. First, given Mr. Dukes' lack of any prior contact with the criminal legal system, it was especially important to ensure that he fully understood the rights that he was waiving. So the court here failed to inform Mr. Dukes that certain rights can never be waived, and in this way incorrectly suggested that the appeal waiver represented an absolute bar. On page 13 of the plea minutes, lines 6 through 8, the court said, "And you understand, sir, that once you waive this right to appeal, you cannot change your mind at a later date," thereby suggesting that the waiver represented a complete bar to appeal. The waiver is also invalid because the waiver colloquy failed to convey to Mr. Dukes that the right to appeal is separate and distinct from the rights forfeited by his guilty plea. In fact, immediately after describing the rights that Mr. Dukes forfeited as a result of the guilty plea, the court goes on to the waiver, written waiver, without explaining that these two are separate and distinct. Also, Your Honor, the written waiver did not relieve the court of the obligation to ensure that the waiver was knowing and voluntary. In fact, Mr. Dukes was instructed to sign the written waiver before the court could assure itself that he had done so voluntarily and knowingly. Oh, I see that my time is up.
Thank you. Let's hear from your adversary.
May it please the court, Diana Lewis for the respondent, the Bronx District Attorney's Office. Your Honors, I would just like to emphasize that this was a man who was driving the wrong way on a street, went through a crosswalk, all with a loaded .22 in his jacket pocket, endangering the lives of all of those pedestrians who had to jump out of the way. And if your honors have no further questions, I'll rely on our papers. Thank you very much.
Thank you. All right, time for rebuttal. We have.
Sure, very briefly, Your Honor, the factual correction, the gun was actually in his front pant pocket, not in his jacket. And again, Your Honor, we just want to emphasize that this is Mr. Dukes' first arrest, his only conviction, and that he was not alleged to have used the weapon to menace or harm anyone. If there's no further questions, thank you, Your Honor.
Thank you. Thank you both. The next case for argument is Lasker versus Department of Education. You can proceed.
Good afternoon, Your Honors. May it please the court, Daniel Dugan for the appellant, Jeffreen Laskar. In this instance, the appellant has met her burden on a motion to dismiss. She sufficiently alleged that the Department of Education's denial of her completion of probationary period and the subsequent termination of her employment was arbitrary, capricious, and in bad faith, as the superintendent who made the decision relied on negative evaluations from a non-administrator in violation of the education law. And
What in the education law defines whose statements can be relied on?
So the education law sets forth that anyone that is going to rate a teacher must be trained to conduct those ratings. The individual that conducted the ratings here, Ms. Toro, and they were included in the superintendent's reasons for the termination, she was a coworker. She was not yet an administrator. She was enrolled in a training program at the time and had agreed, and she writes it in her own papers, that Ms. Laskar had volunteered as one of 2 teachers that year as part of her apprenticeship program. Ms. Laskar had agreed to meet with her, allow her to perform non-rated observations of her for purposes of Ms. Toro's training. She was not yet qualified as an administrator to rate Ms. Laskar. Subsequently,
Counsel, you keep using the word rated as an administrator, but is that an actual requirement? Because what I'm seeing is that the requirement is that the person receive appropriate training.
correct. So the person had to
Doesn't
be
necessarily
trained.
mean it has to be an administrator, right?
Correct, but this program was to become an administrator. She was in training, not yet trained. So to rely on those negative evaluations performed by her as a reason to discontinue Ms. Laskar's probation was in bad faith.
Weren't there other things in the record that supported the decision regarding ending probation?
Sure, so this was her 5th year of probation. She completed the 4-year probationary period. Her principal had recommended tenure for her, but the superintendent and Ms. Laskar agreed to a one-year extension of that probationary period. So when he did that, there were the previous ratings in her employment file. The only things that occurred after he extended her probation, she received 2 informal ratings from her principal, her direct supervisor. They were both overall effective, and also then included in the employment file and the tenure recommendation was the student scores from the previous year, which, as they had been for all the prior years, were effective again. There were no derogatory or negative observations after he agreed to extend her probation. She was improving as a teacher. Instead, like I said, the derogatory 2-page summary and informal observations performed by Ms. Toro violated the collective bargaining agreement. No derogatory or negative remarks can be included in that file without first presenting it to the teacher, giving them an opportunity to submit an answer and rebuttal, and signing off on it. You'll see in the record that those observations and the summary that Ms. Toro prepared, neither were provided to Ms. Laskar. She didn't have the opportunity to rebut them, and she did not sign off on them. Her first time seeing them was when it was given as a reason by the superintendent that her employment was being terminated. Lastly, in place at the time, there was an executive order for teachers that were up for tenure. This was the year that COVID interrupted the school year, and it gave them 2 options. They could either grant tenure, even if a teacher did not have the, didn't meet the minimum of 3 informal observations and 1 formal, or it could extend their probation, not terminate their employment.
Thank you. You can proceed.
Good afternoon, Your Honors, and may it please the Court. Amy McKempfell on behalf of the Respondent, Department of Education. Your Honors, I'd like to briefly address the appellant's points with respect to Toro's observations, the evidence of her unsatisfactory performance, and the executive order. So starting with Toro's observations, the statute that appellant is citing, it says that people who perform evaluations for annual performance reviews need to receive appropriate training. Toro's observation assessments were not counted in Laskar's annual score tracking. If you look at the record, only the assessments from the principal were counted for the 2019-2020 school year. So there's nothing inconsistent with the statute in how Laskar was assessed. To the extent that Laskar is arguing that DOE couldn't consider Toro's feedback at all, there's simply nothing in the education law that says that. In fact, the very first subsection of that statutory provision says that nothing in this section shall be read to affect the unfettered statutory right of a school district to terminate a probationary employee. So it simply does not provide Toro with a basis to challenge her termination. With respect to the unsatisfactory performance, the burden is on the petitioner to show the bad faith, but nonetheless, by providing evidence of her unsatisfactory performance, DOE has rebutted the vague allegations of bad faith and conclusively shown that her termination was in good faith. Her performance was uneven during her years as a probationary employee. She received repeated developing ratings in 4 of the 8 observation assessment categories. And this pattern continued in her final year as a probationary employee. The assessment that was performed in November 2019 by her principal, which is page appendix A73 to A78, it shows that she continued to receive developing ratings in 3 of these 4 problem areas, therefore showing that this pattern of unsatisfactory performance, again, continued even into her final year. And finally, with respect to the executive order, this is a point that Laskar raises for the first time on her reply brief on appeal, so it's not properly before this court, but in any event, the executive order does not say that probationary employees, it does not restrict school districts from terminating probationary employees. All it says is that given the COVID pandemic, school districts can grant tenure if they haven't completed the normal process.
So in other words, it was permissive, it wasn't restrictive.
It permitted school districts to grant tenure more easily than they otherwise would have under the education law given the COVID pandemic. It did not set any restrictions on a school district's ability to terminate a probationary employee. Thank you, Your Honors.
Thank you. Rebuttal, counsel?
Thank you, Your Honors. Ms. Lascar was observed by two individuals in her final year of her probation. She received 2 informal observations from her direct supervisor. There's no argument that that individual was trained. She was trained as an administrator. She was trained to perform these ratings. She gave her 2 effective ratings. Another individual, Ms. Soro, performed these informal evaluations. She wasn't yet trained. She was practicing. She was an apprentice, and she found her, Ms. Lascar's performance otherwise. For the superintendent to then rely on those observations, discredit the effective ratings of her direct supervisor, and rely on the negative performance evaluations and remarks made by someone not yet trained was in bad faith. Thank you, Your Honors.
Thank you. Thank you both. Tucker versus City of New York. Sorry. Yeah, thank you.
Bless you.
Okay, you can proceed.
Thank you, Your Honor. May it please the court, Richard Deering for the municipal respondents in this case. Justice Frank here took the remarkable step of annulling the Department of Education's $31 billion budget and reimposing a different budget, what he called spending levels that the agency has to comply with, even though they're not funded for this year. This is a step that's entirely ungrounded in law.
I have a question directly related to the remedy issue. Assuming that we agree with the trial court that a serious procedural error was made, is there a different remedy that you think would be more appropriate for the trial court or for us to impose?
We've identified 2 theoretically available remedies, one that you could impose. I don't think the petitioners have actually sought it, so I think it's probably forfeited, but it is sought it on appeal, which would be a declaratory judgment, a forward-looking declaratory judgment. There's abundant precedent for that type of option as a less disruptive and more appropriate remedy. Now, I'm not conceding there's a violation. I'll get to that
I didn't ask
later,
you.
but I'm speaking directly to your question.
Thank you.
And I'd look at the cases I'd look to there are Winter versus Cuomo, which is a 3rd department case. This was the first Governor Cuomo about budgeting practices where a forward-looking declaratory remedy was ordered. King versus Cuomo, not a budgeting case, a legislative case, also there. A declaratory remedy in lieu of a retrospective, disruptive, sort of pulling the rug out remedy. And the last one, a little bit different, but also worth looking at, is the NYPIRG, originally versus Dinkins, later versus Giuliani case, which was a mandamus case, but it's still there to a prospective remedy. It was a budgeting-related case involving a substantive defect in the budget, and it was a forward-looking remedy, not an annulment of a prior budget or disruptive retrospective remedy. So those are the 3 things I would look for. I think that's the simplest and most straightforward way to resolve this case in the most critical aspect of it, which is the erroneous ruling of annulling the $31 billion budget that had been voted on and approved by the City Council. And
You said there was an alternative. What's your alternative to that?
The alternative, well, the second one, which I think they're too late for, but the second remedy that would have been theoretically available to them if they had timely sued and pursued it would have possibly been, we would have, and I just want to be clear with you, candid with you, we would have opposed this remedy, but it wouldn't present all of the difficulties that Justice Frank's remedy would have been to sue in the moment, meaning when immediately after the issuance of the emergency declaration
If they'd acted faster.
Yes, and so you need to compel compliance with their understanding of the statute before this final budget vote occurs. That's another option that could have been sought and would have been appropriate to seek. We would have opposed it, but it would not raise all of the severe questions, the severe conflicts with binding precedent from the Court of Appeals that the remedy Justice Frank ordered does.
Counsel, I have another question. If the chancellor had not issued an emergency declaration, or if there had been no emergency declaration, do you agree that the city council could not have voted until after the PEP voted?
No, I don't agree with that because I think fundamentally the point is
that, I mean, just to take
So what's
one-
the point of the emergency declaration process if it wouldn't have made any difference?
Well, I think that the way to see it is, I'm trying to choose my words carefully here. I think that it's clear there's an inference that anything related to the budget process should occur before the final budget is adopted, right? I think that's a fair inference. That's the way it's supposed to go. But it does not mean, and this sort of is related in a way to the point about remedy, it does not mean that if that step hasn't occurred, that the city council is barred from adopting the budget. I just think those are two fundamentally different questions.
So then what's the remedy? What's the remedy if if the city council doesn't follow the law and the chancellor doesn't follow the law? So you say, well, too bad we didn't do what we are required under the statute to do. Then that's literally a remediless violation, right?
Well, I would say two things about that. First of all, the law doesn't say anything. The law that they're citing doesn't say anything about what the city council is supposed to do. This is a major flaw in their case.
Right. Okay, but let's go a step back.
Yeah.
Right. So the chancellor said, "Nah, I didn't do what I'm supposed to do. I sent the mayor my budget without waiting for that vote, which I am required to do." And it was clear, I think it's clear that he's required to do that. And the only way you don't get to do that is by the emergency declaration. Can we agree with that? Do we both agree with that?
I think that's fair.
All right. So if what you're saying is true, then there's no remedy for that very substantial violation.
Well, yeah, I want to try to separate two
Tell
different
me
things.
what you think the remedy would be. What's to stop the chancellor from just sending the budget, saying, I missed it, and the city council from voting? And then what's the remedy?
Well, I think that goes to the point I was trying to make a minute ago. And I apologize for not being clear about it. I'll try to be as clear as I can. They could have sought a remedy that said the council can't vote until this procedure is complied with. I don't think we would have acquiesced in that remedy because I don't think it is that there's nothing in the statute.
We're not talking about the city council. The city council is not, it's the Department of Education, right?
Sure.
That's what they're saying. The that the chancellor can't send that budget to the city council before the PEP vote.
But I just want to clarify a few points. It's not the budget.
I mean, I'm sorry.
It's an estimated budget.
Yes, that piece of it.
It is a non-binding
Yes.
thing. It is a non-binding document. It goes to the
Yes.
mayor.
Yes.
The statutes in question don't say anything about a relationship between the DOE and the city council. The city council is a separate branch of city government. It exercises its own judgment and makes its own votes.
Yes, so I think I was speaking in short, but in fact, the statute says that the chancellor can't send it to the mayor for the mayor to include it in the budget that gets sent to the city council, correct? Before that hearing and the vote.
But there is one amendment I'd make to that, which I think is an important one. Is the mayor doesn't have to follow that estimate. The mayor can exercise his or her own judgment and produce its own budget, and they've never, frankly, and I just...
Nobody has to follow it, but the point is that the information becomes a public record, and it is the way for the public to put in some input in terms of the budget before the mayor and city council exercise their independent discretion about what to do. It's useful and important information.
Don't deny that there's usefulness in it. I do want to make two things clear, though. The city council itself, and this is an important fact that petitioners have never really grappled with, and Justice Frank didn't either. The city council itself holds hearings directly on the whole budget. 2 hearings were held on the education budget specifically, a 3rd hearing that questioned DOE officials at length about the education budget. They produced 2 separate reports. Their finance division that analyzes budgetary questions produced 2 separate reports.
Right, but but we know about those other hearings, but there's nothing in the statute that says if the city council hold lots of other hearings, then PEP doesn't have to.
Agreed.
Right?
And I'm not trying to make that point. I'm trying to make a different point, which is that there is, I don't want there to be confusion that there weren't many and ample opportunities for public input and participation. In fact, hundreds of members of the public did testify before the city council. And just a slightly different point, I know my time has run, but there are a couple.
I haven't stopped you, so
yeah,
finish.
I got you. So I think there are really 3 things further pertinent to your question. One is, and I just want to take a step back to sort of a bird's eye view of the budget process in New York City, which is sort of like the size of a state, but the operational complexity of a city. it is inordinately complex. It calls for input from a huge range of bodies, people, agencies.
You're saying you could just ignore one portion of it and it's okay because
No.
it's satisfied in other ways? There's no dispute that procedures were not followed. The only
But there is a dispute. Frankly, we do dispute
The
that.
only way you could dispute is by saying every year there's an emergency. That every
Well,
year there's really an emergency and it's appropriate to use that emergency declaration. I mean, you keep talking around the real issue, which is whether or not the procedures were followed and whether it was valid every year to keep saying there's an emergency or not. And if it was violated, what's the remedy?
Right.
So all these other things are really ancillary to the question, which I don't really hear you
Well, let me
responding
try to respond more directly to it. The point that I think is most critical, and that is, I think, abundantly established in the case law, is that the failure to follow one aspect of this complex procedure, this sort of agency-level aspect of this complex procedure, does not bring down the whole apparatus and provide a basis to undo the deliberative legislative vote of the City Council. That is clear.
That's the remedy issue. The
Okay.
question is, are you denying the violation?
I am, and
On the ground that there was emergency,
yes,
correct?
on the ground that the emergency.
Assuming that every year for 12 years, there isn't an emergency, otherwise, you are not denying that that didn't happen.
I am denying there was a violation because the chancellor exercised his statutory authority to immediately adopt the estimate on a short-term basis, subject to later ratification by the PEP, which is exactly what happened.
But that was only permitted by the emergency declaration. And it seems to me that, I mean, would you say an emergency declaration by the chancellor would be adequate if it was a piece of paper that just said emergency?
No, but the chancellor did.
I'm not sure that this emergency declaration is much more than that, because all it did was recite the statutory criteria. It didn't recite any facts specific to this year, and it also wasn't any different from the last 12 years that the chancellor also claimed.
There are some variations over the years, but it recited facts.
What
facts? I do think they were facts that have recurred, but I don't see any basis to conclude that that alone disqualifies it. The facts are that DOE is unusual in a couple really important ways that relate to budgeting. One is a huge chunk of its money comes from the state, which doesn't complete its budget process till April. So and Chancellor Banks referred explicitly to that, as have previous chancellors, to the fact that the funding sources do not become known until late in the game. And in fact, one of the affiants in support of petitioners, Tom Shepard, in his affidavit, he said explicitly last year the emergency declaration may well have been justified because of uncertainty about funding sources. He thinks there's a difference all of a sudden this year, but he says it may well have been justified last year, and I think that's fundamentally just a difference of opinion between Chancellor Banks and Tom Shepard about the clarity of the state funding sources. The second thing that's distinctive about DOE is that DOE has this enormously complex logistical task confronting it that happens shortly after the budget process, and requires a lot of planning in the lead up, and that being the start of the school year for the largest school district in the nation by a large margin. And they need to start the planning process in order for that to go smoothly earlier than the 45-day notice.
But you're positing this as an emergency. This is kind of a known complexity that should be planned for in terms of ensuring compliance with the statute, shouldn't it?
Well, I just think fundamentally the job of executive officials like the chancellor is to figure out how to make these regimes work in a real-world setting, and that's what the chancellor, four or five different chancellors have done. The PEP has done it twice.
True enough that that's what they're supposed to do. It requires the planning necessary to comply with statutes, not to say, gee, it's so complex, it's an emergency, I can't comply. I mean, that is, it doesn't feel right, you know?
Well, I hear what you're saying, and I acknowledge it's a close question. I would identify a few points. One is the broad deference to the chancellor, to executive officials in this area. It is not, was he definitely right? Was it rational? I would also just make the second point, which I think is important for the contour of this case. The emergency statute is not carte blanche. It requires a vote of the PEP. That vote happened here. The PEP approved the estimated budget, and the petitioners in their case, it's sort of a defective case in this regard, petitioners in their case have never tried to have that vote set aside or argued that the PEP should re-vote. That vote has to be accepted as valid for the purpose of that case. And so, even if you thought the emergency declaration...
Again, but that goes to the remedy. It really doesn't go to the violation. The violation occurred, whether or not post-violation, it was sort of papered over. And so again, putting aside the remedy of busting the budget, you still haven't really adequately explained why it's okay for every year for the last 12 years for you not to comply with the statute by declaring an emergency. And isn't it the job then of the Department of Education to go to the City Council and say, this statute is not workable, rather than cut the parents out from their right to be heard and the teachers from their right to be heard?
Well,
in this context, I'm not arguing any other context, in this context.
And I'm going to allow you to answer that last question.
Yeah, I will. I just want a few responses, and I just want to make this clear that if we're putting remedy aside from the standpoint of the City of New York, we're putting an awful lot aside. That is very, very, very important, and so I don't want to go too much down the road of fighting with you guys about the emergency declaration without putting a pin in that point and making it very clear. That is the great wrong that was done here, the great disruption that was done here, the core motivation for what we're doing on appeal, and I just want to make that 100% clear. I take your point, Your Honor. I think the reality of the situation is, as sometimes happens, there are some statutes that present some serious practical difficulties in implementation. And there is a view of the world where we say, it would be Albany in this case, not the City Council, where you go to Albany and get it fixed. I respect the view. It's not always as easy to achieve as it is to say. And somebody has to get the budget done and the school year started each year. And we have, in this case, a series of chancellors, and in 2 instances, the PEP itself, that have made the judgment that the way to make that happen is through an emergency declaration. Thank you very much.
Thank you. You can proceed.
Thank you. Good afternoon, Your Honors. Laura Barbieri for Advocates for Justice on behalf of the petitioner appellees. Here, I think the 2 issues are, was there a violation of the education law? And if so, what was the remedy?
Well,
Counsel,
obviously, let's start with the remedy. The remedy. Oh,
okay. So,
I'm thinking, how can we invalidate the budget for the next year? I mean, how could that possibly work?
we're not invalidating the budget. We're invalidating
Department of Education budget for
Right.
the next year.
Okay,
Oh, I'm
that's-
sorry, I keep
that's for
using,
sure.
everybody's
And
like,
then
technically.
The way that we're doing that is because it's an operation of law. The city charter provides that if the budget doesn't pass in a particular period of time, the prior year goes forward. So in this case, Judge Frank found that the budget was invalid that the city council voted on. And because it was invalid, by operation of law, the prior year applies.
But there was a difference. The prior year was a much greater budget than was ultimately approved by the city council, right?
Yes,
We're not talking about a little amount of money. We're talking about a lot of money.
A lot of money compared to what? I mean, in terms of
Well,
every year.
let's talk concrete numbers. What was the difference?
Okay, so let's assume it is a lot of money. There's no requirement,
Yes, we're
and
not
there wasn't
talking
any
numbers.
requirement.
Okay, we're not talking numbers, but let's talk about some practical issues where the money is so disparate, and even if it weren't, the question is that we're operating under a budget that we don't know if there's funding or funding sources to meet.
The budget for the prior year, we agree, was more than the 23 budget. However, the particular order of Judge Frank is not that you have to spend at that level, but you could spend up to that level.
Well, but
And so therefore,
how
what that
significant
means,
distinction, right?
What that means is that, let's suppose the budget last year was you giving $100 to pay a salary, and this year it's only $80. You don't have to spend the $100.
But there's also nothing preventing you from spending $100, and then where would that shortfall come from?
It's simply a question of whether or not the teacher costs that money. If they had the extra money, they don't have to necessarily spend that money.
That it actually concerns a lot more the expenditures than just paying salary of teachers. It involves how many teachers we hire, how many teachers we fire, what resources we have in the schools, how many computers do we have for kids, what programs do we have for kids. So it's a very complex set of decisions that are made regarding spending. And do you realistically think that when the budget is millions of dollars more, that the people who have been given the right to have that are going to say, you know, we're really concerned about the funding sources, and therefore we're not going to put in for 12 additional teachers. It's not going to happen.
I understand the court's point, but I think that it doesn't take into consideration what principals do and how they do it and when they do it. In this particular case, the principals already had an idea of how much their budget was going to be. So even if they said, okay, now we have more money than what we previously had, they can take that into consideration. Judge Frank was allowed to make that determination, and that really is the question here.
So then why are you insisting on the remedy? If you're saying these teachers can do the 2022 budget numbers, why are you insisting that the budget go back to the 2021 numbers? Obviously, because you want them to spend more money, not because you think they're going to be fiscally responsible and say, no, we're not going to spend that extra money. And it's actually close to, I think it was, I'm looking at my numbers, 31.5, and then it went down to 30.88, right? So it's like $500 million.
Yes.
And you're saying that given the Department of Education that $500 million more, they're not going to spend it?
I think it depends on what it's for. I mean, there are two parts of the budget: the operating budget for the Department of Education Central and the budgets for the schools. So in this particular case,
what is to stop them from spending that extra $500 million, even if it's not available in the coffers?
Nothing would stop them from doing that. The question is whether or not it was necessary. And I think that what Judge Frank was doing was putting it back into the political process by allowing this city council to revote. He said, you can revote. If you don't want to revote, it goes back to the 22 budget. He was saying that if you want to revote, if you want to change it from the 22 budget, then reconsider and redecide. You could decide the same thing, or you could decide a different thing, but you can then decide. Yes,
Council, I have a different question, which is that you raised the question about timing when the principals are going through this process. Speaking of timing, the Chancellor made the emergency declaration, such as it was, on May 31st, but you didn't file your lawsuit till 5 or 6 weeks later. It seems to me that once the emergency declaration was made, you could tell with some certainty that things were going to move pretty quickly, whether PEP voted or not, whether PEP had hearings or not. So why did you wait so long to file?
Yeah, I understand the question. I want to do...
Because the remedies would have been very different if you had filed much earlier.
I do want to talk about the timing of it just before I answer your question, just to point out that my co-counsel, my adversary says that the chancellor didn't have a chance to go through the 45 days. But on April 26th, that's when the budget was decided. And he didn't wait, he didn't decide that there was an emergency until the 31st of May. What happened between that time period to make it be an emergency? And so there wasn't anything. He just wanted to send the budget.
I understand that one can argue that the emergency declaration was defective, but that's not my question. My question had to do with your client's choices to not pursue this promptly after the emergency declaration, such as it was issued.
But remember, the emergency declaration is only one part of the case. It is the other part of the case is that City Council voted.
But you could tell once the emergency declaration was issued that that was probably so that no one had to wait for PEP to act.
Yes, but we didn't know when City Council was going to vote, and once they voted, that rendered the budget invalid, and that gave rise to the cause of action.
But when the emergency declaration was issued, you certainly knew or had the same arguments in place that you have here, that in fact the education law was not complied with, and there was nothing to stop you from that point to go in and say, this is invalid, and that City Council can't vote until the Chancellor includes the recommendations made by PEP in accordance with the education law. And I think, that's one of the questions that goes to, even if you're right, the remedies seem so extreme, maybe like, I hate to use this analogy, but, putting a tourniquet around your neck for a nosebleed, There were so many more efficient ways to handle this that wouldn't affect the functioning of a very complex school system.
Well, we understand that it's complex, but we also understand that the violation is very clear and that the remedy was permissible in that City Council could have re-voted. And so the import of what Judge Frank was doing...
Can they still re-vote? Can they still re-vote?
No, they can't until or if there's a budget modification, and the mayor has to come to them with the budget modification.
But let's agree that that's not the only remedy that Judge Frank could have issued, right? That's one of many things he could have done. And you didn't seek that remedy because you were saying to your clients, we're going to hold back and not spend that $500 million. You wanted that remedy because you want to spend that money. Let's be real.
Actually, they didn't come to us until City Council voted. So we are a pro bono firm.
No. I'm just talking about you sought that remedy so that you could spend that money, not just for a Pyrrhic victory of saying you violated the law, right?
Well, assuming that they had come to us at that time at the 31st, which they did not, and assuming that we'd known about it, we could have filed a case, but we didn't know about it and nobody complained about it. So they didn't complain until the budget actually hit the schools. And it didn't hit the schools until the 13th of June when City Council authorized the budget to go forward to the schools. And the money went to the schools then, and only then did the parents realize what had happened.
But may I just ask one last question?
You may.
What remedy did you seek? Did you seek prospective relief, or did you seek to invalidate the budget and go back to the numbers that were $500 million bigger?
What Judge Frank did is...
I'm just asking you, in your petition, I don't have it in front of me. That's what I'm...
we sought that it go back to the budget.
Okay, thank you.
But I also know that Judge Frank elicited from both the petitioners and the respondents suggestions on what to do. And we wrote letters about what to do. And at no time did the respondents suggest a prospective remedy or that this should happen or that there should be an alternative.
I guess
Okay.
we don't have that
Thank
in
you.
the record.
So, yeah.
Just a few points on rebuttal. I'll stay on
Counsel, I'd
remedy.
just like to follow up on the
Sure.
last thing that counsel said. She said there was a request by Judge Frank for proposed remedies.
Yes.
Did you propose an alternative remedy, and is that, and were the responses to his questions in the record? I don't recall that.
I believe the responses are on the record, but there's a clear,
And did you propose a prospective remedy?
not after that time, but I'll explain why that happened. Because
But the answer is no, you did not propose a prospective.
prior to that, if my memory is correct, and I think it is, that we did previous to that in our submissions on the petition, at least in our written submissions, possibly also an oral argument, but I'd have to go back to the record to confirm that we did flag the possibility of forward-looking relief being different from retrospective. But I just want to speak clearly about what happened before Justice Frank. Justice Frank had said orally on the record at the hearing, now this was not me who presented that oral argument, so but he said orally he was going to annul the budget. The question was, what step could he take to do that when we're talking only about one agency, the biggest agency by far, but out of an entire city? How could he accomplish that in a minimally disruptive way? But at that point, the Rubicon had already been crossed of invalidating the budget, the key question. So it wasn't really incumbent on us to come back to him again and reiterate our argument that the only appropriate remedy would have been a prospective one. That issue had been lost by that point. A couple other things that I want to clarify. The petitioner has still, on the key issue, they talk all about this stuff about last year's budget, et cetera, element of the remedy, but they've never confronted really the key first question, which is what is the basis to invalidate the City Council's vote on the budget? The Court of Appeals has been very clear in Wine versus Carey, said you could take that. There's only a handful of cases that have even considered that kind of remedy. They've all involved very different circumstances from this one. Wine versus Carey, the Court of Appeals says this can only be done in the narrowest of instances. Other cases say it can only be done when one of the branches of government, either governor or legislature, or in the case of the city, the mayor or city council, has exceeded the scope of their authority. And in each instance, there's probably 3 or 4. What has precipitated a remedy like that is a defect in the budget itself. Either it contained something it could not contain, meaning the budget document, or it failed to contain something that was mandatory for it to contain. There is no other case we've ever found or petitioners have come forward with that has invalidated retrospectively a budget after legislative adoption. On the timing point, 2 things on timing, and I know I'm wearing out your patience, but 2 things on timing. In Chancellor Bing's declaration on May 31st, he explicitly said there's not going to be time for a PEP vote before the council votes. He made that clear on May 31st. 48 days later, this case was brought. Council vote was on June 13th, still another 35 days before this suit was brought. So I think the timing points are rather clear. Thank you, Your Honors.
Okay, thank you. Thank you both. The State of New York versus Park, People versus Park. You may proceed.
Your Honor, thank you. Your Honors, good afternoon. For Appellant James Park, Andrew Frisch. On retreat, on use of deadly force, on Mr. Chi's belligerence, on so many of the components of Mr. Park's view of the favorable evidence supporting his right to an instruction on justification, there's support, sometimes a little bit of support, sometimes more support, in the people's evidence.
Counsel, isn't the law undisputed that you can't use deadly physical force against someone unless they initially use deadly physical force? That's
I couldn't hear you, Judge.
Unless they initially used that force, you can't use that force. You can't respond with that force unless they come to you initially with deadly physical force. That's undisputed, right, under the law?
Under that scenario, yes, but those
Okay,
aren't
so in
these-
this case, is there any evidence whatsoever, any argument whatsoever based on the evidence that the deceased in this case had any intention or came forward to the defendant with any deadly physical force?
So the answer to that is, let me answer that question 2 ways. And the first answer to that is that Mr. Park is backpedaling. He's retreating. He's surrounded by people, according to his testimony, by people on all sides who were shouting to Mr. Chi to grab the knife and kill him. And Mr.
Did he
Chi,
ever approach with deadly physical force the deceased? Did he ever approach the defendant with deadly physical force?
other than grabbing him and struggling for the knife, no.
So then how could there be a basis for justification defense?
Because Mr. Chi, his testimony is that he perceives a deadly threat under Getz, under LaCicero, under Douglas. It's all of the circumstances that he perceives. He perceives himself being surrounded, someone behind him, people to his side, people to his front. On the other side, there's the storefront. And he's being, and the people surrounding him are encouraging...
That deadly threat, even if that's a reasonable perception, it wasn't from the decedent, it was from the crowd.
But the crowd is encouraging the decedent to grab the knife and kill him.
The knife that the defendant brought, right? The knife that the defendant produced. The defendant was the only one that was armed in this scenario, right?
The knife, that is true. And it's the knife that Mr. Park produced only as he's backpedaling, and this is on their videotape. They conceded in their summation. He produces the knife only as he's backpedaling, only as he's retreating. And as he testifies, he only pulls it out and unfolds it as he perceives himself being surrounded and as people are calling for Mr. Chi to grab the knife and kill him.
But I'm intrigued by your use of the word backpedaling. I watched the video from all the different angles, and it didn't look to me like he was backpedaling. It looked to me like he was leading the decedent away from the crowd, and that it seemed to me to be, he was very active in doing that. He wasn't doing that defensively.
Your Honor, that's...
So it seems to me that that's certainly the way the jury could have seen it, not seen it at all as backpedaling, but as actually a form of aggression, because he was getting away from the people who were allegedly cheering on the decedent.
I don't disagree with that at all. The jury could reach that conclusion in summation on that argument made by the people. But now we're talking about the view of the evidence most favorable to him. And his view is that he's backpedaling from an advancing Mr. Chi.
But Mr. Chi, as you have recounted, is advancing. He has no weapon, correct?
That is true.
Right. And your client then pulls out a weapon to use deadly force. How can that be justification? He pulled the knife out himself.
He did pull out the knife, and as he testified, he pulled out the knife only when the surrounding crowd is encouraging Mr. Chi to grab the knife and kill him.
How could he grab a knife that wasn't pulled out?
Well,
I mean, even if the crowd was saying, kill him, it doesn't really matter. The victim had no weapon, and your client hadn't pulled out a weapon yet. How reasonable a belief could it be? Because it's not just what your client, let's assume that he subjectively believed he was being threatened. It's got to be a reasonable, objective belief as well in order to get the benefit of justification.
Viewing the I'm sorry.
Well, not defense, but you know.
All right. Viewing the evidence in the light most favorable to Mr. Park.
Which we will.
He's surrounded. There's a storefront on one side, so there's no people there.
You keep saying he's surrounded, but there has to be someone approaching you with deadly physical force. There's no allegation that someone else was threatening him with a deadly weapon. He's the only one who had the deadly weapon.
I disagree with.
How can that be a basis?
I disagree with Your Honor's statement of the law. It has to be a perceived threat, a perceived deadly threat. There doesn't have to be a weapon in the hands of the other person. The other person doesn't have to have a gun or a knife. And the other thing the court has to consider is the argument they made in summation, which is all that matters is the moment of the stabbing, that all they have to show is that he intended to kill at the moment when he stabs. Everything else that happened in advance is irrelevant according to their argument in summation. There does not have to be a weapon in the hands of the advancer. Where you're surrounded on a sidewalk, as happened here, and there's a storefront on one side, and his testimony is there's people in front of him, and we know there's we know there's a crowd, it's conceded.
Counsel,
we know
do you disagree that the defendant was the initial aggressor?
I do disagree with that.
How?
Because Mr. Park is on the sidewalk, and this you can see on the video, on the compilation video. Mr. Park is on the sidewalk, and Mr. Chi comes out of the club, and you see him in the lobby indoors before he gets to the door, and he takes his jacket off, he throws it to the ground, and then he comes out. This is on the video. Mr. Park sees that and then takes off his jacket, and they start fighting. And according to Mr. Park, when Mr. Chi comes out, the first thing he says is something to the effect, it's in my papers, you want to go, you want to do this? And then they get into the combat stance. But I want to get back to the question about the weapon, because there does not have to be a weapon. If you perceive a deadly threat as here,
But where's the deadly threat? Even from the description you just gave us, is the deadly threat that the decedent threw down his jacket? I still don't understand from your account where the deadly threat is.
Well, let me break that down into two parts. The deadly threat, which the people said in summation, they said, and this is important, so I'll read it, this act of murder in the moment of the stabbing did not need to be premeditated, no requirement that this intent to kill Howie Chi lasted for any. It's only in that moment. It's only at that moment that the prosecution is required to prove beyond a reasonable doubt that Mr. Park possessed that intent. Now, let's focus just for a moment on that moment. I understand Your Honor's question has multiple parts, but let me just focus on that moment. At that moment, the crowd, he's hearing people in the crowd say to Mr. Chi, grab the knife, get the knife, use it, kill him. And Mr. Chi says something to the effect of, I'm going to grab the knife or take it in an off-color way. He says, I'm going to get the knife and harm you with it. And Mr. Chi, and there's no dispute, according to the people's witness, Miss Mune, she sees Chi strike first. According to Mr. Park, Mr. Chi grabs for the knife and there's a struggle. So in that moment, he perceives a threat. And if you go back and take all that evidence and you look at the case that trial counsel cited to Justice Jackson, which was Cataldo, the taking out of a knife and wielding it against just one person, let alone a surrounding crowd, was perceived in that case, was sufficient in that case to warrant the instruction because the knife was taken out and wielded in a way to repel the perceived attack.
All right, let's hear from your adversary. Thank you.
Good afternoon, Your Honors. Noreen Stackhouse for the people. At the outset, Cataldo was, I believe, decided in the 90s, and since then, the Court of Appeals has made clear in People v. Brown that waving a knife around, even as a deterrent, still makes that person the initial aggressor. It's undisputed in this case that the victim was unarmed, and this wasn't a situation where the victim was pummeling defendant to the point where the defendant could have perceived a threat to his life. The video does not show a crowd surrounding the defendant. As Your Honors clearly have watched the video, you know that when he took the knife out, there is no one around him, not even the victim. But even crediting defendant's testimony that he was surrounded by people who were telling Howie to kill him, he was still not justified in responding to verbal threats by pulling out a knife. And he also had to justify the force against Howie, not the crowd. Defendant had no objective basis to believe, even with the crowd egging Howie on, that Howie would kill him or injure him because Howie didn't have a knife on him. And at that point, Howie had not even thrown a punch. Defendant punched him once, and then they squared off, and then defendant pulled out the knife. If there are no further questions, I'll ask the court to affirm. Thank you.
Right, just to kind of deal with this justification defense, it's not enough that the defendant testified that he subjectively believed that he was being physically threatened with deadly force. There has to be an objective component to it. And that is really why this defense didn't apply in this case. Isn't that your position?
Exactly, Your Honor. The justification, there's two elements. There's a subjective element and there's an objective element. And no reasonable person in defendant's position could have believed that they were being subjected to deadly force such that they had to bring out a knife.
Okay, thank you.
Thank you.
All right, rebuttal.
Thank you, Judge. Even if all that is the case, even if what my adversary said is true, there's no reasonable view of the evidence that it's not intentional murder. This case is one of two things. It's either an intentional murder of which he was acquitted, or it's not a crime. It's not speculation to say that the prosecutor wanted the lesser included offense or was arguing for it as a compromise. She said, but quickly, and these are her words in summation, but quickly, with regard to the manslaughter, the crime of conviction, but quickly, it's really only if the 12 of you unanimously decide that the defendant is not guilty of murder. She doesn't say much more. I quote all of it in my brief. If you look at the other evidence, take Your Honor's questions this afternoon and consider what the prosecutor said in summation about the intent to kill. When you stick a knife in another human heart, your intent is clear. Is there another possible reason to stab another person in the chest multiple times other than intent to kill? The only reason that one person would ever stab another in the chest multiple times because he would want him dead. And this comes back to the cases I cite about shooting someone in the head, which is that if you shoot someone in the head, you intend death. There could be some strand of evidence, maybe supporting some other view, but the courts don't even permit a lesser included offense under those circumstances, let alone proof beyond a reasonable doubt. And that's this case. They analogize stabbing Mr. Chi in the heart to shooting someone in the head. There was no theory advanced for manslaughter as opposed to murder. There's no evidence of it. If this is a crime, it was intentional murder by the 2 stab wounds, one to the heart, one to the lungs, 6, 7 inches deep, but he got acquitted of that. And so the question is, well, what's the evidence that he intended serious physical injury as opposed to murder? I submit most respectfully to Your Honors, the answer to that question is none.
Okay, thank you. Thank you both. I always give the last case on the calendar special thanks for your patience to sit through our very long calendar.
Oh, man, my knees are bad. How's it?